your interpretation. I have an amendment, so I'm going to pass that out now so that we can work off of that. Yes.
Is that a different amendment than the one you sent to us?
No, it's the same one, but in case people didn't print them out, I obtained copies of it. Yeah, one for the file and one for you. Correct. This is the same amendment that you received via email, just providing hard copies for those who don't have one. Does everybody have a copy? What's that slide? Yeah, I passed half that away. Okay, so as you see, I broke it up into two sections, Roman numeral 1 and 2, and that's because this bill is doing two separate things. So Roman numeral 1 states that a local governing body shall not prohibit a person as defined in RSA 382-A:1-201B27 from operating grounds, maintenance, or snow and ice removal equipment powered by internal combustion engines on any property within the municipality. So nothing was changed there. It was just broken. That first sentence was broken out into a Roman numeral 1. So discussion on that provision of this bill. Is there any comments? Okay. So I would assume everybody's okay with Representative Stavis. You look like you have a comment.
Thank you, I do. Thank you, Madam Chair. So under RSA 382A:1-201B27, individual encompasses corporations, business trusts, estates, partnerships, limited liability companies, associations, joint ventures, governments, public corporations, and any other legal or commercial entity. Is that the ban? Are we banning all of those entities from instituting a ban?
So thank you for that question. So yes, clearly this bill, Roman numeral 1, is a ban on a ban. So essentially what it does is it preserves the status quo. Yes, Representative Colby.
If I may, I'm not sure on work session protocol.
Yes.
May I ask Representative Stavis a question?
I'll allow that.
Okay.
Yes, it's a work session.
So are you saying that currently the RSA defines a person, the definition of a person includes government, but yet in Section 2 we are excluding the government? Okay. All right. Now I understand. This one we didn't have, the sponsor wasn't able to attend, right? The prime sponsor?
That is
My
correct.
notes. Okay.
Yeah.
So we don't know the legislative intent necessarily of this bill.
That would also be correct, and
Okay.
that is unfortunate. And the prime sponsor was invited to participate today.
So-
And
So if we don't know the legislative intent, is it wise that we pass a bill that might then have to be reviewed by a court who would then attempt to determine legislative intent?
so right now we're not executing the bill.
Right.
We're working on it. We're analyzing it, going through it with a fine-tooth comb. We're coming to our best understanding that we can arrive at collectively and collaboratively. And we're working to identify if anything may need to be changed in this bill. As a working point, it would be this amendment. So that's our goal and our aim right here and now in the full committee work session. So your point is well taken, and I would, that's probably appropriate to bring up during the executive session. We'll see as we go along, whether we stay with this or ask for another amendment from OLS for that executive session. So I think we're not there yet.
Thank you,
Yeah.
Madam Chair.
Representative Davis?
Thank you, Madam Chair. So I understand that the prime sponsor did not show up to present the bill, and the prime sponsor decided not to be here today. Is that correct?
Well, thank you, Representative Davis. At this point in time, I do not see the prime sponsor. I can't say that he chose not to be here. He was made aware of it, and he has been noticed. And to be clear and honest, the commute was not fun for us to get here. Like I had said, there were 4 accidents in my route, but nonetheless, we will work through this session, and if the prime sponsor shows up before I close this work session, then he may have the opportunity to answer questions and give us an overview of this. If he doesn't, then we will go into the executive session with no input from the prime sponsor. Again, your point is taken, and that I would ask to be reserved for the executive session. Representative Majori. Oh, okay. Representative Franz and then Representative Majori.
Does this mean that a corporation could not purchase any combustible engine machinery or anything, and they don't have the opportunity to back out like the municipality does in the next paragraph? Is that correct?
I am not the prime sponsor of this bill, nor did I write the bill. What I did in putting forward this amendment is to take what was filed and referred to this committee and to make it more clear going on what was in front of me in the bill. So Roman numeral 1 says a local governing body shall not prohibit a person. So like I said, it's a ban on a ban. So unless I'm misunderstanding your question, I don't see what you're saying. I don't understand what you're saying. If anybody can answer that better, Representative Colby, can you? Do you understand?
Me or?
No.
Me.
Sorry. Representative Grund.
That's okay. I think the confusion is that this is not banning, this is saying that you cannot ban gas. I think you're confused that it was trying to ban them. What it's trying to say is you can't, yeah. So,
Correct.
yeah.
Right.
Yeah.
And is that not a ban on a ban? Is that too simplified? Yes. Right. Okay, so Representative Majori, you were next.
Thank you, Madam Chair. So, like I
No.
didn't turn my mic on, sorry.
Okay. So you referenced Roman numeral 2, and we're not there yet, but let me open up discussion then. I kind of wanted to focus on Roman numeral 1 and get beyond that, and to clearly understand what that is doing. And yes, the subject in that Roman numeral 1 it's the authority is the local governing body. Okay? So does anybody have any other questions? Yeah. About Roman numeral 1. Yes, Representative Majori.
Thank you. So it's actually the same question. In Roman 1, the governing body can't prohibit. Could a citizen's petition be put forward to do the exact opposite? Because the legislative body is different than the governing body.
So I'm not a municipal attorney, but based on, my experience on this committee, I would say no, because the state has not explicitly given the authority under RSA to do such a thing. So because it's silent, it would be a no. Representative Gilman.
I've forgotten my question.
It's all my fault.
It's
all his fault.
we can come back if you want.
No, I guess the question is, does this, could this fall instead of being a separate law under things that because it's just referencing the governing body, can it not be an ordinance created by the governing body?
Thank you, Representative Gilman. So my response to that would be it's the same as I gave to Representative Majori, that the state through RSA needs to give that authority to the local municipality in order to do such a thing.
Okay, thank you.
Representative Davis? Oh.
Thank you, Madam Chair. Not working. Now it's working. Okay. So because RSA 382A1 broadly defines person, that includes corporations, business trusts, and all other kinds of structures like that. If this were to become law, would that mean that a local governing body could ban a private corporation from prohibiting the use of internal combustion engines? And would that not be unconstitutional? And my second point,
Now it's working. Oh, okay. So the language here says that a local governing body shall not prohibit, and the object of that verb is a person. And then the language further goes on to reference or point to RSA 382, where person is defined. So your question is, because there's a pointer to RSA 382-A, et cetera, the rest of that, and that definition also includes other entities, the question was, could there be a prohibition on those entities from operating internal combustion engines on property within the municipality? And as a legislator, not as a municipal attorney, my answer would be no, because the state hasn't given that authority in statute. Yes.
I would disagree. This is not working again.
You know what? Here.
I can talk loud, that's okay. So I would disagree with that assessment because it does say as defined in RSA 382, and the definition in 382 is very, very broad. So if I were an attorney, I would pick that apart. And my second question has to do with the last sentence in section 1 of the amendment. It's line 7, and it says, on any property within any municipality. I don't understand that. So if my governing body institutes this ban on the ban, does that mean it can also institute it on any municipality's governing body?
Thank you for pointing that out, Representative Davis. The interpretation, one could, in fact, in my opinion, interpret it as you have explained. However, to be clear, I found this bill to be poorly drafted and the language to be confusing. So I'm quite certain that the intent of the prime sponsor, it's just sloppy language. And that was the intent was the local governing body within a particular municipality. But I do see your point.
So with respect, and then I promise I won't say anything else, we can't know the intent of the prime sponsor because the prime sponsor was never here. Unless you've had a conversation with the prime sponsor and you know the intent. Public know that.
Yes, Representative Davis, I would agree. The prime sponsor, we don't public unless and until the prime sponsor comes before this committee and discusses the bill, introduces the bill, explains the bill. We don't. It would constitute hearsay. So we just don't know. So Representative Elwood.
Thank you, Madam Chairman. So I'm a little bit confused. Was this bill introduced?
Yes, Representative Elwood, the bill was in fact introduced and we execed it and it was retained.
Okay. So do sponsors come to work sessions, and at work sessions, is there interaction between the board and?
The answer to that is yes. So are we good with section 1? Representative Grund.
I think where I'm frustrated, I know we've heard it multiple times, though, if we don't know the intent, how can we work on this appropriately?
Thank you, Representative Grund. We're doing the best that we can in the time here that we have. And I would recommend that we proceed to section 2. So section 2 reads, notwithstanding paragraph 1, the legislative body may vote to prohibit the municipality from purchasing any ground maintenance or snow and ice removal equipment powered by internal combustion engines, and may vote to rescind such action in the same manner at any duly warned meeting. So as you can see in the bill as filed, the prime sponsor it's enabling, and the prime sponsor is allowing the ability for the municipality to prohibit the municipality from purchasing such equipment. So in my amendment, and again, this is just a starting point, this RSA 41 falls under town, so I thought that in order to uphold local control, that it should be the legislative body. Now, if people don't agree with that, we can make an amendment and make changes. That's the whole point of a full committee work session, is to have a discussion and work together to potentially come to an amendment or not. You know, we can, when we get into executive session, we can move forward with this amendment, or we can move forward with the bill as written. We'll have to see how that carries. Any questions or, well, I guess comments, because I can only answer questions with regards to changes that I made. I'll go with Representative Colby.
Thank you, Madam Chair. I do want to thank you for the change. I think that was an appropriate change in Section 2 on your amendment to move it to the legislative body. If anyone would have commentary, I'd be interested in hearing the reasons why we would set a double standard, a higher double standard for the municipality versus a person or a corporation. That everyone around Public Works Department would be able to operate this equipment, but the Public Works Department itself could be prohibited from operating the same equipment. If someone has a good reason why we may want to allow a legislative body to vote for that, I would love to hear. Thank you.
Representative Karazinski, did you have a response or an idea or a thought as to why that would be a thing to
you.
do?
Thank you, Madam Chair. Just my comment on that, I guess, would be that the road agent would still be perfectly within his right to buy whatever equipment or recommend the purchase of whatever equipment he wanted. And the governing body, again, could buy internal combustion or non-combustion machines. But the legislative body could also use local control and prohibit the governing body from making the purchase of internal combustion machines. That's the way I took it.
Representative Colby.
Thank you. Just a quick follow-up. So I understand that aspect, but I feel that the legislative body already has that ability. Like someone could write a citizen's petition without passing a new law to say that we don't want you to purchase that particular equipment. So I'm not sure that we even need a paragraph, or excuse me, a section 2 in this bill to accomplish what section 2 would accomplish. But thank you so much.
I'm going to make a comment. So when I looked at the language in the bill, right, I think what people need to try to visualize or understand is that I would agree that a municipality, the governing body, could put an article on the warrant saying we're going to buy solar powered whatever or electric chargeable pieces of equipment. They can do that. So that's like a positive action. Reading the original language of the bill, there may be a municipality where just that particular municipality just doesn't want to use combustion engine property maintenance equipment. They just don't want it. So Roman numeral 2 is allowing the voters of that municipality to say we're to prohibit the purchase of such equipment. So that's enabling them to make that decision to say we're not purchasing any of this type of equipment. We're going a different route, whatever that route would be. So it is, and when I was looking at this, I had the same thought that you did. It's like, do we even need this second section? Because there's nothing preventing a warrant article from, being, coming before the town to vote on the purchase of non-combustion engine equipment, property maintenance equipment. But, what's the word? But in thinking about what, if a municipality just would, everybody wants to, not everybody, but the majority would like not to purchase such equipment, this is a mechanism by which they could, where the state is allowing them to do that. So in the second section, it's enabling legislation that allows the voters to make the decision that's contained within Roman numeral 1. It's at the heart of it. So just very quickly, so that decision-making doesn't lie within the governing body. It would lie within the voters to prohibit and say we're not purchasing this type of equipment. I hope that helps. Let me go to Representative Elwood, then I'll come to this over there. Representative Elwood.
I did have a follow-up to my introduction question about what did we learn from the prime sponsor at that time, if anything. And I agree with Section 2 and your analysis.
Thank you, Representative Elwood. Representative Fracht.
Thank you, Madam Chair. If I may back up to lines 3 and 4, there's no definition of snow and ice removal equipment powered by internal combustion engines. Are we talking about a snow blower? Are we talking about a sidewalk plow with a sander behind it? Are we talking about a pickup truck with an 8-foot plow blade? Are we talking about a 8-wheel dump truck with a spreader on it? All of those are snow and ice removal equipment. So I feel we don't have a definition that we need in order to pass this bill.
Yeah, thank you for Representative Fracht. When I first read this bill, prior to the hearing, I had the same exact question. So that being said, I'm not aware of any like snow plows that would be solar powered or rechargeable. So I think, yeah, point is well taken, but the application would be to equipment that there is an alternative out there on the marketplace. That would be my response.
Are you asking me to repeat what I said?
No, I'm just thinking. Yeah, I agree. It doesn't say that. Are you aware? And I'm being totally like serious. Are there other parts in RSA where a dump truck is defined? I don't know. I think it's just, it could be an issue. Yeah. Representative Gilman.
Thank you, Madam Chair. I guess my question is, or maybe comment, is that number 1 prevents a local government body from using snow or ice equipment, et cetera, internal combustion energy on any property within the municipality. So that means private property as well as municipal property. But number 2 only involves municipal property.
That is correct. So so any property within, it should really be the municipality. So yes, that would include municipal property as well as private property. And the notion is that the local government, some people have the opinion that the local government should not have the authority to ban what a private citizen uses on their private property. So there's that. And then with regards to, so taking that philosophy forward into section 2, yes, you are correct. It is not symmetric. It's saying that the legislative body may vote to prohibit the municipality from purchasing the maintenance equipment. So what was the second part of your question?
I guess my question is that these are two separate manners of doing, sort of doing the same thing, but one is, puts the legislative vote on the wrong end, I think, because number 2, or number 1, the legislative body already votes on this kind of equipment through, for the most part, because of the cost. It depends on your municipality, but because of the cost of a piece of equipment, it goes into either the budget or a special warrant article, which the legislative body already votes on. So I guess my question is, why is it necessary?
I think I feel that it's permissible. There are things, we always have things that appear in separate warrant articles that raise and appropriate money for specific purposes. And you could argue, well, for certain things, well, why isn't it in the operating budget? I don't really see a problem with having a separate provision. In my opinion, we see that, we currently see that. Representative Walker.
Thank you, Madam Chair. To me, this boils down to two simple facts. Section 1 prohibits the legislative, the governing body from prohibiting private people, citizens from using snow blowers on their driveways or whatever. Section 2 says the governing body can decide whether they want, as a municipality, to use them on, in the municipal department can use those. So that's why it's separate too. The government can't impose, you can't use combustion engines on its citizens, but it can impose that they're only going to use electric snow removal equipment, bottom line. It's fairly simple. It's kind of messy wording, but that's the bottom line what it says.
And the other thing that I wanted to point out is with regards to Roman numeral 2, so the municipality, when they purchase property maintenance equipment, they will be using that on municipal property. Just, I wanted to point that out. Representative Stavis, did you have a comment?
Yes, thank you, Madam Chair. In line 6 and line 9, we have the word operating in the first instance and purchasing in the second instance. I'm confused by that. What if my city has already purchased a whole ton of electric battery-operated snow removal equipment? If this bill is signed into law, do we have to get rid of it and buy internal combustion equipment? And what is the difference between operating and purchasing, and why are they in the same bill?
So purchasing means procuring, obtaining, and operating means using. So what was your first question? Your first question was saying if a municipality already has like electric grounds maintenance equipment, you feel that this bill would prohibit them from using that? I'm not seeing that. Could somebody expound on that? Representative Gilman? Where would that be?
That would be in the effective date. It's 60 days after the passage of the bill. And if you already have already purchased, whatever Representative Davis said, if you already have internal combustion engines, you have to change them within 60 days.
Doesn't say that. No.
Well, you have to, I'm sorry, you have to prohibit them within 60 days.
Representative Majori?
I don't have an answer to that question, so if we want to continue down that road, I'll yield. I just have a different question.
Ask your different question.
I don't mean to be snarky in saying this. We've asked about the prime sponsor being here to ask the question. Are we trying to solve a problem that exists? Do we have any history of this problem in a municipality, and are we trying to solve something? It seems like we're trying to solve our own language, but I don't know that we're trying to solve a problem.
So that's a good question, Representative Majori. So if the prime sponsor was here, we would be able to ask him and come to that understanding. So we don't really know right now. Thank you. Representative Elward?
So I can't, speaking to your amendment, I can't help, or the bill, I can't help but wonder if this is an air quality control issue. And what is the state's interest in air quality control by passing your amendment?
Representative Elward, I'm not seeing the connection to air quality control within this amendment because the amendment is a clarification. It's a better formatting of the bill as filed. I'm not seeing where you're getting the hook with regards to this being about air quality control.
Well, internal combustion engines emit emissions other than and that is what this is speaking to. There doesn't seem to be any other reason.
You're surmising the reason why this bill was filed. Your guess is as good as mine. Representative McDonald.
Thank you, Madam Chairman. I think what I figure the intent is to not allow the towns to tell me that I have to buy an electric weed whacker, electric snow blower, or electric chainsaw because of the noise if I want to go out and do something in my yard at 9 o'clock in the morning. I think this is the intent. I have heard some communities are thinking about adopting things like this, where they could actually do a time frame rather than tell the individual businesses or the individuals in the community what kind of lawn maintenance equipment or what type of snow blower to buy, whether it be gas or electric. One other comment, if look at it, notwithstanding, I looked that up for definition, and let me just pull it up here on my phone, if I can. Let's see. Come on. Miss Davis, did you fool with my phone?
How did you know?
And the definition of notwithstanding is in spite of. So I read that in spite of paragraph 1, they're saying that they're giving the authority to the legislative body to prohibit or purchase the internal combustion engines and may rescind it at any time. So they have to buy the electric stuff. So sometimes you've got to look at the previous definition, which is notwithstanding, to see that, in my mind, that exempts the requirements of the definition of personal person in the above paragraph 1. Thank you.
Thank you, Representative McDonald. Did I see a hand over here? Okay. Representative Majori.
I hate to ask this question, but I have to. In paragraph 2 from line 9, any ground maintenance equipment, does that include repair parts, or would this be all new?
So my interpretation of this language is that equipment is a piece of equipment. It's something that you can pick up and use. A part is a subset. It's, you can't like take apart, like, I don't know, like a filter, right? That could go in, I don't know, like a leaf blower. You can't take the filter and use that. Like, it's useless on its own. So equipment is the item, the functioning item itself. Thank you. Representative Davis.
Thank you. Just a couple of things. First of all, I'd like to commend the chair for scheduling this bill for a work session, because in the course of this work session, I think what we have figured out is, absent a sponsor explaining to us what the legislative intent is of his or her bill, we're just guessing. And I realize that these bills become the property of the committee and not the sponsor after they're submitted, but we're still just guessing because we can't ask the sponsor questions. And I wonder whether that's appropriate for a legislator to do when considering any piece of legislation, is to kind of wonder and guess about the sponsor's intent and maybe make up some language that the sponsor didn't intend to use at all. I just feel that it's a very slippery slope, but I do commend the chair for putting it into this work session. Thank you.
Thank you, Representative Davis. Your points are well taken. And as a reminder, we're in a full committee work session. We're not in exec. So we will take those comments, and that will inform us when we exec this bill at 1 or sometime thereafter. Further comments? Okay, well, seeing none, the chair will close the full committee work session on House Bill 453. So at this time, the chair will open the full committee work session on House Bill 488. Just get it. Relative to limiting conflicts of interest for municipal board and committee members. So first, I would like to provide a brief background information for committee members who were not on this committee last term. So House Bill 488, it's a refiling of 2024 House Bill 1124 that was recommended by Municipal and County Government Committee ought to pass with amendment. And that amendment was number 0979H, and the vote was unanimous, 20-0, and it passed the House on consent and went over to the other body. So when this House Bill 1124 got to the other body, as typically happens after crossover, the other body, the committees are overwhelmed with the number of House bills that they get, and they just, they're overwhelmed. So that bill 1124 was recommended interim study. So the bill essentially died, and as a result, the prime sponsor, it's my understanding, took the input from the Senate hearing, and the bill was refiled as House Bill 2025, House Bill 488. So with that, at this time, the chair would like to invite the prime sponsor, Representative Spilsbury, to provide further background with regards to what I just said, if my research was correct. you can add to that and explain, the status of this bill. And then I'll take it to the next level. Thank you, Representative Spilsbury, for being here this morning to participate in the full committee work session on this bill. And I would like to welcome you to municipal and county government.
Thank you very much, Madam Chair. Good morning, members of municipal and county. I'm Representative Walter Spilsbury, otherwise known as Terry, Sullivan District 3, representing the towns of Charlestown, Newport, and Unity. Thank you for the introduction. And I want to apologize for having been unable to be with you at the end of January. I had already bought tickets from my mother-in-law and my wife to go to Arizona, and seeing my calendar free, I bought tickets 3 days before the trip, and then the calendar changed. So I really appreciate the opportunity to sit with the committee again. I think that my predecessor bill in the last term, HB 1124, was a major success of this committee. It involved presenting it, and sitting with the committee a year ago was a very constructive exercise. I can still recall very specific comments from Representative Stavis, Representative Gilman, Representative Howland, and others. And so what we did is, with a very open mind, we made a number of changes to the bill, and those were reflected in the amendment that this committee adopted. So it really went to the Senate. I think is an excellent bill, and I would echo the chair's comments, having talked to Senator Gray, that, yeah, they just, if there was even the slightest change that it might require, they were so overwhelmed that they couldn't deal with it. So here we are again, and the only changes that were made in 488, this bill, relative to 1124, last year's bill, were a couple of minor word changes in 1B and 1K that were designed to iron out clarification issues that were raised at the Senate. And it's my understanding that the chair will have an amendment that, in fact, deals with both of those and makes them better than they are in 488. So I don't want to bog down in them, but the primary objections or concerns that I've heard about 488 are pretty much the same as lingered last year. And those are, number one, that the New Hampshire Association of Town Clerks are concerned with a variety of permutations that allow them to also be a tax collector. It's my intention to not interfere with the ability of a town clerk to also serve as a tax collector. So it was drafted to allow a town clerk to be a tax collector by specifically referring in line 8 to, if authorized as provided in RSA 4145A. You're probably aware that 4145A allows a municipality to take a vote to merge the two positions and elect a single official to both positions. A change already got made to add in deputy town clerk. Another change already got made to add in elected or appointed, or appointed. And finally, an edit was made in HB 488 relative to 1124 to add at the end, or deputy tax collector. So I just want to be clear. My intention is to accommodate the concern of the town clerks and allow a town clerk to also be a tax collector, a town clerk to also be a deputy tax collector. Whatever combination of these things, it's okay with me. I think that the language in 488 already does that, but I think the sticking point is that clause in line 8, if authorized as provided in RSA 4145A. I don't think it would harm the bill at all to just delete that clause, okay? The purpose of this was to make a hard link and reference to another point in statute, but the purpose was not to say you can combine town clerk and tax collector only when the municipality votes to do it under 4145A. Okay, so I would like to suggest to you that the concerns, as I've heard them from the town clerks, either have been addressed or can be addressed with that one deletion. The other change in language was very minor in K on lines 26 and 27. And basically, this sentence, as it was written in 1124, tripped on too many oars. So it was hard to parse the sentence out. I think this is, again, it's my understanding that the chair will offer an amendment that supersedes this and just simply solves the problem in a different way. But let me just be clear what the intention is. RSA 32, 14, and 15 establish the power of a municipality to create a budget committee. And it defines that statutory budget committee and its membership very carefully. And so it talks about how many at-large members there are, and there can be one member of the select board. If there's a school district entirely within town, there can be one member of the school board. And it precludes a whole bunch of things, including it precludes a full-time employee or a part-time department head from being on that budget committee. What that doesn't fully account for is that there are also municipalities that have not adopted the formal budget committee process and instead use a finance committee on a purely advisory basis. And so what this language in K is trying to do is say, it doesn't make a difference whether it's the statutory form under 32, 14, and 15, or the advisory form under, I forgot which provision that is, but it's also in RSA 32. In either case, it's a conflict of interest to have a full-time employee of the town or a department head sitting on the finance committee and voting on their own department's budget and their own salary. And this is something that I'm proud to say, I worked very closely last year with Nate Graves, who was the attorney for the Municipal Association, and NHMA endorsed this bill after the various changes we made. So I think, if there are any other questions and issues that arise today, I think the bill is extremely important. Let's just address those issues, make any surgical changes that are necessary. I don't want to get hung up. I want to see this passed. And so far, I have avoided giving illustrations of how these problems play out in my communities, as well as many other communities that I've heard from since introducing the bill. If you have questions, I can go into those details. But for right now, I would just simply say, I think this bill is extraordinarily important. Thank you.
Thank you, Representative Spilsbury. So at this time, in order to facilitate the full committee work session on this bill as a starting point, I have an amendment that I shared that we could work from, because these are ideas that we need to discuss. So I'm going to pass around the amendment, and I also have a side-by-side comparison to facilitate our analysis and look at this bill in our discussion. So again, the goal here is to collaboratively and together to go through this bill line by line and come up with an amendment if needed. So to make things easier, I would like to suggest that we take this in small parts, bits, and we work from the side by side that I prepared. So wait till everybody gets their handouts. So with regards to the side by side, let's take a look at what is labeled as row 1. So as a starting point of discussion, I added in fire ward and also also a fire to modify department. So it would include the police or fire department with regards to full-time duty. So simply, this amendment is adding in the positions of fire ward and a full-time fire chief to the list of positions that can't be held concurrently. So comments about those inclusions? Representative McDonald.
In my community, the moderator is also the town moderator, and he's also the school board moderator. So would he have to choose one or the other, or could he do both?
Representative Spilsbury, that's comparing the two. So that moderator language is in House Bill 488, so I will defer to the subject matter expert and the prime sponsor of the bill to address that inquiry.
Representative McDonald, I think that's actually a common situation, and it's not in any way intended to be precluded. So we're talking here about municipal offices, right, as opposed to school district offices.
Yes, Representative McDonald, you may follow up.
Thank you, Representative, for your comments, but again, I'm trying to understand if he's the moderator of the town, wouldn't that be a violation if he was the moderator of the school district within this statute?
Well, I would defer to the committee for your understanding of how our statutes are structured. It's not my intention to preclude a moderator of a town from also being a moderator of a school district. If it's the committee's intention, well, I defer to you. But I think that the way that the wording is in the bill is not addressing the question of the school district's officials. It's addressing the municipality's officials.
It doesn't specifically say school district. It's saying conflicts of interest in municipal government, which would be towns and cities. A school district has its own section of statutes. Follow up?
Yes, if you go to paragraph E, line 18, no selectman may also serve as either a school board member serving the same town. So it does mention some possibilities involving the school board itself. Again, it goes to line 22, no selectman, moderator, town clerk, deputy town clerk, school district clerk. I think it needs some clarity that wouldn't prohibit someone from being a moderator of both the town and the school district.
I would have no objection to making that clear.
So Representative McDonald or any other member of the committee, how would you like to clarify that? What could you suggest some language to help make that clear? Because that's what we want to do is we want to come out of this with an amendment.
Madam Chair, if you can just give me a minute, I'll write something up here.
Okay.
Could be a simple exception sentence.
Representative Majori.
And while you're writing that up, village district moderator? Because that's within the municipality. I'm assuming that.
Yeah, I think, again, this is not something that had occurred to me. I think it's a fair distinction that you're trying to make, and I think it was accurate that the question of village district and school district are addressed in other provisions. So I think it would be fine to just write a single sentence exception that makes it clear that a moderator of a municipality can also be a moderator of a village district or school district.
Representative Majori, could I conscript you to a job? Sure. Could,
I'm going to conspire with McDonald, though, on it.
could you please keep track of what we want to amend, just so we don't miss anything and we address and the fruits of this full committee work session are not in vain. Representative Davis.
Thank you, Madam Chair. In the spirit of this being a work session, I'd like to ask a question of my colleague from Claremont as it applies to city governance. We have members of the city council who sit on the planning board and have other appointments elsewhere in the city. This bill states that they are in ex officio capacity, and I am asking on the behalf of cities whether that in fact is true or whether they're voting members. I believe they may be voting members, but I'm not sure.
So in our municipality, they are not there as ex officios, they are there as voting members. They are voting members.
Right, so that would present a problem for cities as it is written in this bill.
Thank you. Representative Spilsbury, I'd like you to comment on that, and I will proceed with this. I'd have to look up 669.7. This is for towns. Cities, it's a different section. Is that correct? No. Okay.
669.7 is under Chapter 669, Town Elections.
So it's towns. This does not pertain to cities. Correct. Is that correct?
That's my understanding. I would also say that the RSAs regarding towns include, for example, that the planning board is comprised of a number of elected members plus one ex officio from the select board. That is a voting, fully participating ex officio. So to use the term ex officio means basically it's an appointment from the select board. It doesn't mean that they vote or that they don't vote.
Representative Gilman.
Thank you, Madam Chair. I'd just like to clarify, ex officio is often confused. It is in Latin by virtue of their office. And in fact, in the various other aspects under 673, which is referenced in here, they are expressly voted as a select board member, can be a member of the plan, or is assigned to the planning board ex officio with all the duties of a regular member.
That's precisely what I was saying.
And then I have a follow-up on a different line.
All right, so just to be clear, is your question in the comments, we want to stay, because this bill has a lot of sections and it's a lot. So I don't want to jump around. I want to stay focused on each row or line. And then once we've fully discussed and analyzed and come to a conclusion on that, then we can go to the next section, because it can get confusing to jump around. So does your comment have something to do with Roman numeral 1?
I guess my comment does have to refer to that.
Okay,
or,
perfect. Yep.
And throughout the bill altogether.
Okay. Oh, did you have I thought you were going to ask another question.
Well, you wanted to not skip around, and I'm not sure where this fits, but it's the definition of appointed officials.
Does the word appointed, is that tying into Roman numeral 1A?
No.
Okay, so let's hold on that.
Okay.
Representative Elward.
Thank you, Madam Chairman. I'm wondering, Representative, why land use board members, whether elected or appointed, are not included in this list under Roman 1 of the amendment.
So, it's a good question. You know, what brought me to this in the first instance is that I've been very active in the government locally in Charlestown before being elected to the State House. I served on the Heritage Commission and chaired it. I served on the Planning Board and chaired it. I served on the Finance Committee. And it came to my attention when I was chairing the Planning Board that we had two members who were also on the Conservation Commission. And looked up the RSAs, realized there's a specific prohibition against more than one. And so we talked to the two members, and one of them politely decided to step off. Well, that got me focused on this area of law. And I started researching, and I found how scattered the provisions are relating to limitations on different combined positions. So the land use boards are addressed pretty carefully. So for example, there is statute that says you can't have more than one member of a planning board on another land use board. There's a RSA that specifically defines land use board. So it's a ZBA, it's a planning board, it's a heritage commission, it's a historic district commission, it's an agriculture commission. There's a whole nother provision that sets up what a conservation commission is. And then there's a further part of that provision that says no more than two members of a planning board may sit on any other board. And yet I can tell you in my town, there's routinely 3 or 4 who are on both planning board and finance. So these provisions are scattered. And the most comprehensive of them is 669.7. And if you look at 669.7, the way it's currently written, it's a collection of 7 sentences strung tightly together. It's very, very difficult to parse, right? So the purpose of the bill here was to tease out additional problems and to rewrite 669.7 in a way that it could be easily seen in subparagraphs, each having their own point. But the purpose was not to pull together all those other scattered provisions around the statute. So I think the answer to your question is that if you look in the land use provisions of the RSAs, you find very specific proscriptions. They don't need to be incorporated here. And I guess it's my position that, remember this 1A that we're looking at here is essentially an expansion of the first 2 sentences of 669.7. And I wasn't trying to preclude somebody who sits on a planning board from being on other things. It's so you have to read the sentence and then move on to the next sentence and see what it does in combination. And we do include in here a provision which says a full-time town employee or department head cannot be on a planning board. So, you know, there are specific iterations that are in here. Does that answer your question?
Yes, sir. Thank
Okay,
you.
thank you.
Representative Colby.
Thank you, Madam Chair. I am just wondering, knowing the definition of a conflict of interest, again, I think this question would apply to both the original bill and your amendment. Could you give me an example or two of how something nefarious that a town clerk could do that would be a conflict of interest if they also happen to be the appointed fire chief or appointed police chief? What kind of conflict would that create?
So thank you very much. I don't think you really want me to give you an example of every combination here, right? There are many combinations. But I would start by answering your question. Do I think that there is an inherent problem in terms of conflicts of interest or some disclosure of inside sensitive information from being a town clerk and a fire chief? No, I don't think that. But when this bill was drafted, it and it's still here in 488. If you look at the analysis, it says the bill limits conflicts of interest and excessive concentration of power for municipal board and committee members. So the purposes of the bill were twofold. They were conflicts of interest. Now, let me give you a perfect example of a conflict of interest is where a full-time town employee or department head sits on the budget committee or the finance committee and votes on their own department's budget and their own salary. That's a conflict of interest, as squarely as I can put it. I think that there are a lot of lesser examples that might be harder to pin down or illustrate right here. When a town clerk particularly is coupled as a tax collector, they're privy to all kinds of information, and how they might use it in various other positions is an open question. Fire chief? I don't think so. But the other purpose of the bill is to prevent undue concentrations of authority and power. And I think, we soft pedaled that a little bit last term. It was brought up by Representative Gilman. And we took the reference to concentrations of power out of the bill's caption. But in fact, the excessive concentration of power is a primary purpose of the bill. And the point is that you have to recruit a variety of people to step into these positions so that you don't end up having too few people making too many decisions for one municipality. And I could give you all kinds of illustrations about how that is a problem today. So you could have a town clerk who's also the tax collector, and then is also the town administrator, and also sits on the planning board and chaired the planning board, is also on the finance committee until recently, and is the clerk of the works for the sewer department and the water department. This is just not a good situation. Whether you define it as a conflict of interest isn't necessarily the only flaw, the only problem. It's also a problem to have too few people making too many decisions. So I think I went off track earlier when I was introducing the bill to you, that the other concern I've often heard is one that I'd like to address very directly, and that is, it's said that it's difficult to recruit people to take these positions. How can we really man so many positions? And that's a challenge. It's a primary challenge. My mother was 50 years Democrat committee woman, mayor of our village, ran the Family Service League, was in so many different organizations. And she told me over and over again, in every organization she sat on, her number one job was to recruit new blood, was to bring in people. And so here's what I've seen. When a community has too tight a group, I'll use the word incestuous, there's a groupthink, there's a narrowing of input and thoughts, and it's very off-putting. And so many good people who would step forward and volunteer see this situation of a tight group controlling everything, and they say, I'm not going there. And so what actually happens is the more you concentrate, the more you drive away good people. And I'll give you an illustration of this, because I've heard this in my community. When I was asked to be a planning board chair, I said, okay, you know, I've been on this for a few years and we're just calling balls and strikes on you know, subdivisions and site plans and so on. When was the last time we did a master plan? It had been like 20, 25 years. I said, okay, I'll agree to be chair if we tackle the master plan. And as any of you have been through it, if you take a master plan seriously and you follow the RSAs in all the categories, you've got a very big task ahead. So I got the planning board to agree that we would have 11 task forces. Each task force, depending on its responsibility, would have 5 or 7 members. I then went back home and I got on the phone and I saw people and I buttonholed them and I looked at them in the eye and I said, I need you to step up and be on the economic development task force. I need you to step up and be on the housing task force. And we got 65 people, serious, competent, focused people to step in and man those task forces, and got the something like 100-page master plan completely written after a 25-year vacuum in 1 year. So that's what you can do. So my response to that is, don't allow concentrations of power to get too tight, and leave the responsibility with local officials to be active recruiters. And if they do it, they'll succeed.
That was your question, right? Follow up?
Thank you, Madam Chair. So I don't really feel like I understand, Representative, where you're coming from. Unfortunately, we need to deal with the actual language in the bill, and the language indicates a conflict of interest. So that is why I was asking what specifically would be a conflict of interest between those two groups. So I don't know if there is an answer for that, and what would preclude, if this is running rampant in a town you represent, as an example, there's nothing stopping the local community from standing up for themselves and using the powers under 3139A, where a town can establish an ordinance at town meeting to be stricter than existing statute, to put many of these provisions into place without stepping on the toes of other communities that may need the flexibility due to lack of volunteers. So I appreciate the effort in trying to diversify the representation, but I think we already have the power to do so. And unless we can really get into the nitty gritty on what a conflict of interest would be between these positions, I don't, I'm not seeing it, but I welcome any input.
So I understand your point. I'm also very familiar with 3139A. But you can imagine the dynamics of getting the town to go through this and each town to do it separately, particularly if the local controlling influences are so tight already, if that's the problem that you're trying to address. Second part of my answer to you is that we already have 69.7. 669.7 already says no person shall at the same time hold any two of the following offices: town treasurer, moderator, trustee of trust fund, selectman, and head of town's police. This has been reformulated only slightly, not to change the law, not to make it move in a new direction. If you're uncomfortable with the specific addition of fire ward or fire, then you know, I don't think it's a bad addition to this, but I don't think that the bill is weaker without it. I think that one seems to be the one that you focused on. But if you look at the other combinations here, do you want a selectman to be the treasurer? I think it's very obvious that's a conflict of interest. Do you want the selectman to be the moderator? The moderator is supposed to be an impartial overseer of the process. I think that's a clear conflict of interest. Trustee of trust funds. So I think that if you look at the bill the way I have it drafted, it doesn't substantially, in this provision, it doesn't substantially change the existing law. It's just being rephrased here as a subsection so that we move on to other subsections that make changes.
Representative Colby, so in the amendment that I have drafted and I'm offering to the committee, as you can clearly see that I added fire because the bill as drafted speaks to a full-time police department head. So it only made sense to me that why wasn't fire department head full-time duty included? So that's the reason for that. And it sounds like, you have a question about that and the addition of fire ward. We're here to discuss it and come to a consensus. So moreover, the reason why I included those is that, these positions, they have a lot of increased responsibility. And so my thought is that with that increased responsibility and duty to the citizens of the town, that these positions, you can't do more than two properly and with competence, and to provide that public service that the public expects. So that was my rationale, and like I said, we're here to discuss if we want to change anything. So did you want to change something? Did you want to?
Thank you, Madam Chair. I think that in that case, we need to take out the statement, eliminate conflicts of interest, because what we're talking about is not conflicts of interest. We're talking about consolidation of power, or we're talking about you have too many responsibilities. I think we're using the wrong term in that it's not a conflict of interest to serve both positions. You're saying that it's a conflict of competence at that point. So I think we're using the wrong words to describe these positions. And I know I understand and respect that it's in an effort not to create an RSA that is, 75 pages long while you identify each and every possible conflict of interest for each and every possible combination of positions. I just think that towns are doing their best to not create a conflict of interest by having certain positions combined already. So if we need to change the wording around section 1.
Thank you. Representative Spilsbury, so the original bill as it was drafted, it repealed and reenacted 66097. Could you comment? Is
Sure.
Roman numeral 1 in order to eliminate conflicts of interest in municipal government? Is that currently in statute or
Okay,
not?
it's a very good question. Thank you. The answer is no. So the current statute says incompatibility of offices. And you can be incompatible for any number of reasons, right? And it sort of can be read broadly. I think it would be perfectly okay to simply keep that caption. The purpose of this prefatory phrase was to indicate the purpose. And as I say, when this was originally drafted, and I think this is an alternative, it said conflicts of interest and excessive concentrations of power. There was some sense in the discussion last year that perhaps reference to excessive concentration of power somehow involved a negative connotation, that that's situation going on that we're troubled by. Well, the fact is it is in certain places. I'm not saying it's endemically or everywhere. It's true. But, these are tweaking. Let's make these changes. If this is a bug, make the changes this morning and let's not let the bill bog down over it. I frankly don't care whether it says incompatibility of offices or whether it reincorporates excessive concentration of power. I'll let you decide. So long as my goal is at 1 o'clock, you all vote yes.
Okay, Representative Guthrie is recognized for comment.
Thank you, Madam Chair, and I'd like to ask the chair to excuse me for being late, so I appreciate, if you'd appreciate to do that. And we looked at the question, the item of the moderator, and I agree with that point of view, but I have a hard time saying that the trustee of trust funds and the selectmen are not compatible, or there's a conflict there. What is the conflict between a selectman holding or being a trustee of a trust fund?
It's a great question. I would say that first, just to be clear, this is current law, right? So bear in mind that 1A is not much changed. It's from current law. It combines the first two sentences in the current law. And so trustee of trust funds and selectman combination is already precluded in law. I'm guessing that the thought process was that trustees of trust funds are fiduciaries responsible for the long-term investment and so on of certain funds. They may have certain specialized background or knowledge in terms of investment, and they may be insulated from the temptations of selectmen to look for funds to spend now.
Representative Majori.
Thank you, Madam Chair. Just a general point of order, I guess it would be. Are you going to, would you be willing for us to ask questions or welcome the representative from NHMA if we have a specific question that might be relative to them or they might be able to help us with? Just curious.
Is the representative an attorney?
I don't know. I don't think he is.
No, I'm just asked the question. Let me think about that. Let me go to the side, Representative Elwood.
Thank you, Madam Chairman. Representative, even if we go with incompatibility of offices, and I know that there's statute that enables municipalities to create their own conflict of interest ordinances by a vote of the legislative body. And I know, is it statute or case law that defines conflict of interest in New Hampshire? Nowhere do I really see nepotism addressed. And is not nepotism an incompatibility? And how is that not addressed?
Okay. I think there's a couple of questions there. It's very interesting. In the last term, Representative Lascelles specifically asked the question whether the bill HB 1124 should be amended to deal with the question of nepotism. And I put together language at that time that would have done that if it was desired. And this was my stab: no two individuals who are married or immediate relatives within one generation removed or members of the same household may serve on the same municipal board or committee simultaneously. In the discussion last year, it was felt that that might be a very sound idea, but it should be introduced separately as a distinct bill and not mixed into this. So I listened to the voice of the committee as I heard it at the time, and I thought, that would be probably a really good bill. It would deserve its own discussion, but let's not mix it.
Representative Frocht.
Thank you, Madam Chair. In both the original bill and in the chair's amendment, it refers to a full-time head of police, police chief, or fire chief, according to the chair's amendment. And I don't understand and could use some help in understanding why a full-time police chief or fire chief would have a conflict of interest, or it would be a concentration of power if they're working 40 hours a week. But if they're only working 32 hours or 20 hours, why would that conflict or concentration of power disappear?
Representative Spilsbury, could you also frame your response to that question and also speak to the current law? Because I don't want to expend committee time debating what is currently on the books.
Yes, exactly. My answer to you, Representative Frack. By the way, thank you for stepping up and introducing the bill back in January in my absence. Just similarly with Representative Guthrie's question, Representative Aylward's question, this is already current law, right? So if the committee does nothing, that remains. And so in the current law, it specifically includes selectman and head of the town's police department on full-time duty. So I mean, it's an interesting question you've raised, but I don't know that we need to tinker with it.
Representative Davis.
Thank you, Madam Chair. I would just like to address the question of nepotism that was raised. And I do believe that that would require a constitutional amendment, since the New Hampshire Constitution quite clearly states every inhabitant of the state having the proper qualifications has equal right to be elected into office.
Interesting comment. But not anybody is allowed to be in any combination of offices. That's clear.
Okay, so in order to keep
the
this,
nepotism thing is not on the table, right? Certainly, I'm not putting it on the table.
I'll reserve my, I guess, response or comments with regards to that New Hampshire Constitution for the executive session. Representative Gilman.
Thank you, Madam Chair, and thank you for taking my question. Throughout the bill, the word appointed office is used. Particularly, I'm looking at the town clerk and deputy town clerk can't serve on as an appointed official. Would you consider a planning board member in towns that don't elect a planning board, but towns that appoint planning boards? Would you consider those planning board members appointed officials?
Well, there's no question that some communities appoint planning board members, select board appointment. So I think you started with, you're not aware that there's a definition of appointment. What we have is we have an array of RSAs that specifically authorize certain ways of fulfilling certain positions. And those explicitly state whether it's by election or whether it's by appointment or whether it's by option. So, the question of whether what appointment is and how a select board gets the power to make an appointment, that's found in a whole array of RSAs. I don't think this bill changes it at all. But more specifically, do I think that a town employee, a full-time town employee or a department head should not be on a planning board? And the answer is yes, I think they should not be, and it doesn't make a difference whether they're elected or appointed.
Follow up, Madam Chair.
Yes.
I guess my real question is getting to is why a town clerk, for example, or a deputy town clerk who have to live in the town cannot be appointed to an historic district commission or a conservation commission or something like that. why are they excluded from serving in another, serving their community in another way?
Not to interrupt Representative Gilman, but is that in this? It's,
Well,
but we're focused on line 1, right?
I understand
Okay,
that
maybe I don't
there are
understand.
interrelations.
People have been asking questions all over this. Why am I being subjected?
No. Because this bill's, there's a lot to it, and I'm trying to manage how we work through this bill because I want to hear from everybody. I want input. That's the purpose of a full committee work session. And if we're talking about, I don't see town clerk in this first section. I welcome your inputs and your concerns to make this bill better when we get to those sections, but correct. Yeah, row 1. So we've spent a considerable amount of time on row 1. I want to conclude and move forward. Did you can respond to that, but I'm
Yeah.
just trying to keep people focused and on track.
I think this might be helpful. I've heard 3 issues regarding 1A. One is to clarify that a moderator of the town can also be a moderator of a village district or school district. No problem. Second is fire ward or chief. That's not in my bill. It's in the amendment. I defer to the committee's judgment. Good either way, as far as I'm concerned. And the third is this question of whether conflicts of interest, adequately characterizes the bill's purpose. And, again, I defer to the committee. If you want to just call it incompatibility of offices, that's okay with me. If you want to reintroduce the term concentrations of power, that's okay with me. Those are changes that you can agree to today, I'm convinced.
So let's address those. So with regards to the moderator of a village district or a school district, Representative Majora, you have that listed that we're going to change that and address that, correct?
I have the ones that we've all agreed to, at least by consensus.
Yeah.
There's only one so far that we've agreed to. by
Correct.
consensus.
So now we're going to talk, let's go to Representative Colby. Your suggestion about changing in order to eliminate conflicts of interest in municipal government. Let's iron this out. So does anybody have any proposed language that they would prefer and think is better? And yes, Representative, okay. Colby?
I would feel we just run with the current 6697 as incompatibility of offices.
So, Representative Davis, can we, are you comfortable with just doing a little straw poll here? Okay. So, so what we're gonna just raise our hands for, to just to move forward and to come up with an amendment would be that wording to revert back to what is in statute right now. Representative Grunt, do you have a
Yeah.
question?
Yeah,
Yeah.
my struggle on figuring out which way I want to vote is going
Uh-huh.
to be on the intention of what we are doing going forward. If we're going to address the idea of it being conflicts of interest, then we're going to look to see who has power over who, or who has appeal over who. That is a conflict, that is what I would say a conflict of interest. If you're going to go with something that's a concentration of power, or whatever term you want to do it, that is a totally different concept. And I don't know what we're addressing with this. If we're just addressing conflict of interest is one thing. If we're going to address concentration of power, that's a different thing. So that's why I'm struggling which way I would vote.
What does current RSA
Well,
say?
I would suggest to you that with incompatibility of offices and the way the current statute is drawn, they had more than just conflicts of interest in mind. I think that there are a whole number of reasons why it may be unwise as a matter of public policy to have one individual holding 2 positions. And that's already clear in 1A. I would encourage you to think in terms of incompatibility of offices subsumes both of these concepts, or put undue concentrations of power back in and be explicit about it, which frankly, I think would make the bill stronger.
Representative Davis?
Thank you, Madam Chair. I think at this point in the discussion and before we have a straw poll, it would be highly appropriate to ask the representative from NHMA to comment on this specific point and this specific point only. It is not my understanding that only the sponsor of the bill can speak at a work session. It is my understanding that any member of the public can speak at a work session, and I myself would greatly benefit from that opinion.
Thank you for your input, Representative Davis. So who speaks at a full committee work session is at the discretion of the chair. So due to the fact that there's variations of language, I will permit the representative from the New Hampshire Municipal Association to answer.
Well, I thank the chairwoman for letting me speak today. Again, Brody Deshays with the New Hampshire Municipal Association. I thank the prime sponsor, Representative Spilsbury, for letting me share the table with him. My question, before I answer your question, just for clarity, is your question specific to row 1? Is it specific to our position on row 1? Is it specific to the incompatibility statutes? There's, we've discussed at least 3 different statutes that establish incompatibility. I just want to make sure.
So
I'm
we're
understanding.
we're working off of that's the side by side, and I
Yes,
guess right now we've been discussing row 1 of the side by side, so that is Roman numeral 1 in A. So we can talk about the amendment, we can talk about House Bill 4088, and also what's currently in RSA. So focusing in on that section across the 3 parts, that's what we're looking at. So, because we're trying to get language, so we can choose to go to, as our springboard or starting point to be either 488 or Amendment 2944.
And Amendment 2944 is the amendment that you brought
Correct.
forward today.
Yeah.
Okay, thank
And
you.
so that comparison between the bill as referred to this committee and the amendment is in front of us on the side by side.
Yeah.
Does that answer your question?
That does, and
Okay.
I appreciate, I just want to know what my constraints are. I don't want to be straying too far outside of,
So we're trying to, Representative Colby, we had 3 issues. Representative Colby brought up the concern about what follows Roman numeral 1, starting with the word in and ending with the word government. So we're trying to come to a consensus as to what wording does the committee would we like to see there.
thank you, Madam
Your input?
Chairwoman. So my understanding of the incompatibilities of office is that it's primarily setting a baseline for all municipalities or political subdivisions for what are offices that clearly have incompatibilities in respect to conflicts of interest, where there's specific checks and balances, or you can notice usually has to do with like the handling of money or the approval of like manifests or approval from expenditures of trust, treasurer approving, checks or signing off on checks, and ensuring that someone isn't concentrating all the power over the monetary power in a municipality or those controls. It's especially important you go through your audit process when a municipality is audited, that there aren't officials who are holding a lot of, multiple offices of like treasurer or trustees of the trust funds. So, in RSA 669:7, they clearly separate that these people who are handling different monies and approving different manifests, that they can't all be concentrating power there because of those inherent conflicts of interest. I think it's also important to remember that there's other incompatibility statutes, although they're not titled incompatibility statutes, but where there's prohibitions on who's allowed to serve in specific municipal boards, whether it be a municipal budget committee established under Chapter RSA 32, the municipal budget law, RSA 673:2, the land use board statute, how they're either appointed elected and who's permitted to be on different land use boards. There could also potentially be village district statutes that have some level of incompatibilities that hasn't really been discussed today, and I need to do further research to comment further on that. I also think it's important to remember that the Constitution of the state, Part 1, Article 11, does have a sentence at the very end of that section that explicitly states every inhabitant of the state having the proper qualifications has equal right to be elected into office. And so, you know, if our belief after talking to our legal counsel and prior to sending you the committee a letter on January 28th of 2025, you know, registering our opposition to some of the incompatibilities of office being established under the drafted 488, those offices don't have inherent conflicts of interest. Like an example would be if someone is an employee for a Parks and Rec department, what compelling interest is there to prevent them from running and serving on a planning board? Is that really fair? Does that really meet the intent of our state constitution? Is that really the intent of the legislature to say, well, just because you're a full-time employee in a department that has duties and even your scope of work is completely unrelated to that municipal board, are you now prohibited from being able to serve on the planning board? And this is also why we're in strong belief that RSA 31:39-A does handle these issues where municipalities that struggle to recruit and find folks, that does cover it because the legislative body is empowered to basically tell their government, we personally believe that these things are incompatible or might present an issue for governance or conflicts of interest. And, you know, that's above and beyond the state's baseline. So I think just in sum, our position that we shared on January 28th is a study committee or a commission with local officials and state officials might be the best way because we're talking about a lot of moving parts to address today and being able to have all the stakeholders together to make sure that things that truly aren't incompatible aren't deemed such in
The
law.
witness shall suspend. It sounds like you're giving testimony. I thought you were answering a specific question with regards to wording. So,
I felt as if I was answering the question. I mean, we support the language as currently RSA 669:7. I'm just trying to give.
I think that
Addition-
probably answers
Okay.
the question. So, Representative Davis.
Thank you, Madam Chair. This actually does raise a question for me, and I believe for the committee, so I'm grateful for that explication. So there are currently several RSAs on the books that deal with compatibility of offices. Is that correct? And this particular one deals with potential financial irregularities and conflicts of interest. So I guess the question I'm asking is, are we trying to amend the wrong RSA? Or are there other RSAs that we ought to be addressing in addition to this one?
This is the RSA that's in front of us. It's 669:7. So I want to focus on that. And I want to come up with some language that people are more comfortable with and better indicates what these, I guess, prohibitions, if you will, are about. So Representative Spilsbury.
Thank you. There are two comments that have been made that I'd like to rebut gently. First of all, 669:7, as it's currently in statute, is not by any means limited to financial conflicts. They play a very substantial role here. One can impute that. There's no question about it. I think that's why 1A, for example, is heavy on, as Mr. Deshaies just said, on positions that handle money, like the treasurer and the trustee of trust funds, collector of taxes, auditor, and so on. But if you go through these provisions, they move well beyond that. That's the first provision. Second, it's not in any way the purpose of this bill to override any other provisions of law. it's very intricate area of law, as you guys have all revealed here with your questions. And I think all the questions have been sincere ones, where you're just trying to make sure that we don't write new flaws into the law. But I can assure you that when I went through the drafting process with OLS, we looked at 36A, conservation commissions, 38D, energy commissions, 48A, housing standards, 194B, chartered public schools, 673, local land use boards, et cetera. And we were completely convinced that this bill does not in any way conflict with or override any of those other provisions. So that's the second point. I think the third point is, I think the constitutional provision that indicates a right to run for elected office is an important one. This is in no way diminishing that. We already have this vast array of RSAs that limit particular combinations, and 669(7), as it's in current law and in this bill, is in that vein and goes no differently. Okay, so I think that consider also, if you really thought that that constitutional provision represented a barrier to limiting somebody's right to choose any combination they wanted, then we would have to repeal RSA 3139A, which gives the municipality the power to write its own ordinance that goes beyond the state statutes.
So, okay,
I don't think that constitutional provision, as important as it is, limits the ability of the legislature to rule out certain combinations.
So let me make a suggestion at this point in time. I am looking at the 669:7 as is in current statute. So after that number, 669:7, it simply says incompatibility of offices. So if you look on both the amendment and the bill as filed, it says 669 municipal office limitations. So that I guess is the heading. It's incompatibility of offices or municipal office limitations. So I think what we want to do right now is I would suggest perhaps keeping that header and perhaps striking Roman numeral 1 and then just going right into no person, as is, I just lost the page, but there's no language with a colon. So we could just strike that if it's causing problems, and we could decide to go with municipal office limitations or incompatibility of offices. Does that sound like reasonable?
That would be fine with me.
Okay. So I think the first decision that we would like to make is, do we want to just strike in order to eliminate conflicts of interest in municipal government? Would that clarify things? And in that way, it mirrors exactly what's currently in statute. So I see some heads being up and down, yes. So can we raise hands if you're in agreement with striking that language? Nope, just, this is in preparation for an amendment to be drafted today. So what I'm recommending is we simply strike Roman numeral 1 in order to eliminate conflicts of interest in municipal government. Just those words I just said and read. I'm going to strike that. It looks like people are in fact in agreement, so Majority, could you note that?
So it's just striking the language after Roman 1.
Up to including the colon.
Including the colon.
So the next decision that we need to make is, do we keep municipal office limitations, or do we revert back to RSA after 669? This is just a header that says incompatibility of offices. And then after that, if you look what's in current RSA, it says no person at the same time shall hold. So, does anybody have a suggestion? Would we be okay just keeping municipal office limitations? I mean, I'm fine with that. Does anybody have any comments? If you want, Representative Colby.
I will again state that I think the preference is the terminology that is already familiar to
Okay.
municipalities, which would be the incompatibility of offices.
Okay. That would be fine personally with me, so I'm gonna put that out there. So instead of making this change here, let's just stay with what's already on in statute. So it would read, we will strike municipal office limitations and put in incompatibility of offices. So everybody who supports that change, indicate by raising your hand. Yes, okay, so we will do that. So moving along, how does everybody feel with regards to my suggestion about including fire ward and/or the fire department? So let's deal with fire ward. Are we okay with fire ward, yes or no? Representative Elwood. Oh, Representative Colby, you have a comment?
As a matter of fact, I think we should be changing even the police section to indicate that if you are appointed versus hired, that you could also be the police or fire chief, as an example, or fire ward. I don't know that there is a conflict of interest if you are being appointed, whether you're the treasurer or the moderator. I mean, and I know it sounds crazy, but if we're going to get into the nitty gritty, we're going to need to separate just line one. We're going to be here a while, because it is not. I have heard no testimony to indicate why it would be incompatible for a deputy treasurer, for an example, to hold the position of an appointed police chief or an appointed fire chief. I have heard no indication. So if no indication is given that none seemingly exist, then why are we prohibiting? I just don't understand why we would
Okay.
prohibit.
So I'm going to comment, and then I'll invite Representative Spilsbury to follow up or also comment. So in my reading of this bill, it doesn't matter if somebody, it says that you're in the role of police chief or fire chief and full-time. So my reading of the bill is that covers appointed, does it not? And then you had a second comment?
I think it was more of that that the job is different. Generally, the job is different if you're an appointed versus if you are a full-time employee. Those job descriptions don't always look the same from community to community, which I think is why if we go back to the original statute that we are trying to throw out the window and rewrite, that I think that's why this statute is not as complicated or complex as we are trying to make it now. Because there are so many situations in which you could try to cover.
So this is my opinion that in absence of testimony, that doesn't mean that an idea is invalid. We as legislators, we use our reason and our common sense to legislate, to make laws. So I would offer that for consideration. And with regards to, do we all agree that it makes sense to include fire department chief? If we're including police chief, Yes, so could we just raise hands if we like fire being added in there? Unanimous. So how about fire ward? What do we all feel about fire, the position of fire ward? Representative Elward? Oh, okay. Well, are we okay with including fire ward? Do we want this in or out?
I'm against both, so we don't need to.
Okay. Representative Karazinski?
In some towns near me, the fire wards don't really act individually. They're part of the board, just like the Board of Selectmen. And so an individual fire ward shouldn't be precluded from being on in any other position, other than they have some knowledge that might help.
So the fire wards oversee the fire department. So there's a conflict there. Still, they have authority over the fire department. We're not really paid either, but I mean, I don't think that whether you're paid or not is an issue.
If you removed fire ward but left or fire in, doesn't that cover it? Head of the town's police or fire department? And I don't care
Fire
whether it's
ward
on
is not a
full-time.
fire chief.
Right, if you don't have a fire ward or board of engineers, the Board of Selectmen take that responsibility. So they're giving the responsibility to this other board to run the fire department. So they're not competing on anything.
So do we want fire ward in or out? Out. Who wants it out? Okay, it's out. Representative Davis?
Thank you, Madam Chair. And somebody raised the point of people who aren't appointed or elected but are hired, and which raised a question in my mind that I'd like to pick the brains of my colleagues in cities here that have city managers. And this bill and this statute is silent on the subject of city managers. And I'm just wondering if we're going to be talking about other hired people who are in positions of authority in a city. There's no one who has more authority than the city manager over all of the departments. And so I guess I'm asking the sponsor, did you think about that? If so, what did you think about that? Do you think it's worthy of discussion?
I'm not sure I'm capturing everything you've just said, but I think that we're dealing with a statute here that governs towns, municipalities, not cities. This is under 669 town elections. I mean, you're telling me you know the statutes in this arena better than I do. So I won't try to answer that.
In what we're discussing that applies to a city. The city structure is totally different.
Well, that's my understanding, but subject to correction.
I would agree with that.
You know, there's nothing in this statute that deals with the city. City structure is like a pyramid.
Right.
All
So
comes from the city manager.
if somebody wants to file a bill to deal with that another time with regards to cities, they could. But this is just focused on towns. Representative Grund.
So one of the pieces that I'm thinking is missing here, and it's just because I look at the background, my background being an auditor. There is nothing in here that says like a selectman, treasurer, trustee of the trust funds cannot be a finance director or anyone who writes checks, oversees any manifest. That, if you're going to start delineating, that needs to be added. That is
So,
absolutely a conflict.
Representative Grund, are you suggesting to add that to this list?
Depends what people call it in the town. I mean, my town uses finance director. I don't know what other people use, so.
Okay, we'll put that on hold. Representative Murphy?
Thank you, Madam Chair. I was just thinking of a real simple amendment. No person may be elected, appointed, or municipal employee may serve on another as a committee, board, or employee of the same municipality.
I appreciate that suggestion, but that radically deviates from what we're working on. I think, in my opinion, it's more confusing. I don't know what other people think. I would prefer to kind of just step through what we have in front of us. Otherwise, yeah, we're going to be here. I know that this is important. We want to get it right, but we also want to remain focused. So Representative Grund, could you recommend a term? Could it? Finance director is the first one that comes to mind, but they call them controllers, they call them.
Sorry. And finance director is coming, but person who oversees the finances. I don't know.
Could I ask, so within a town, you're saying that at town hall,
We have a
There's
director
a
of finance who
director of
runs the accounting department that oversees all the manifests, all the reporting.
mhm,
But if you had a selectman in that position,
mhm.
right. Same with trustee of the trust fund. They shouldn't be a deputy treasurer. They shouldn't be any of that.
Yep. Mhm.
You'd have to expand it to not just selectmen, though. You wouldn't want them to be a treasurer. You wouldn't want them to be a trustee of the trust funds. You wouldn't want them to be anything that has to do with cutting checks.
So we
Correct.
could, finance,
Finance.
something
head-
and we
the
can ask
finance dep-
OLS.
Yeah.
Representative Majori, you're typing? Are you looking something up? Okay, we'll let him do some research. Mr. Deshays, do you have any thoughts with regards to what we're talking about? Could you recommend a phrase or a term that we could add to this list to address Representative Grun's suggestion? It's a. You weren't paying attention. That's okay. I'm just joking. I know.
Sure. So in the selectman, treasurer, deputy treasurer, trustee of the trust funds, collector of taxes, any firework, town fleet, they also should not hold the position of like a finance director or someone who's responsible for cutting checks or reporting.
I would say yes, a finance director probably shouldn't hold any of those positions.
No, we know we
What-
don't want that. We're just
What's the
coming up
common
with
term? What's a
the
common
term
term? I
that's
mean, I
going
know
to cover
what
everything.
our town uses, but is finance director like a common term or a head of the finance?
I mean, the selectmen have fiduciary responsibilities
Yeah.
though too, so that might be a little.
Why don't we say,
I think
what'd you say,
finance.
John?
I think finance
Director?
I think finance director or equivalent position that might cover it. I think reasonably, a select board or town administrator or manager would read that language in statute and understand the intention.
So why don't we, Representative Majori could note finance director in. Perfect. Perfect. Thank you.
Yes, I'm back. Sorry.
Representative McDonald, did you raise your hand?
Yes, Madam Chair, I think we've pretty much covered row one. Can we now move on to
Yes,
row
I
two,
was just
please?
going to say that. Representative Frocht, yep. Do you still on one?
Yes,
Row.
I am.
Okay.
I again raised the question of full-time versus not full-time. And if we decide to go with full-time, why are some of the other positions that could be full-time, such as treasurer or highway agent, why would they not be included if they are full-time?
So Representative Spilsbury, with regards to his question, current law is what pretty much we see. Could you, full-time versus whatever he's asking?
Well, clearly, on full-time duty is in the current statute. It wouldn't trouble me at all if you delete that phrase.
Thank you. And I would note, or at least my understanding is that we are, the bill repeals and replaces. So anything is fair game?
So because of the section and all the changes, that's just the way OLS chose to draft it so that it's easier for us to analyze and read. So yeah, we're looking at the bill as filed. So yes, this is the purpose for us to collaborate and make any changes. So Representative Spilsbury, with regards to the issue of, were we talking about part-time and full-time? Well, a part-time job takes up less time, right? Because it's part-time. It's not 40 hours plus or whatever. So do we need to address part-time? Because I'll go back to my comment about full-time position is full-time. And so your focus is on that full-time position. Whereas, you know, you can have part-time positions, you know, you could have two that could add up to 40 hours. It's just the time in the workday. So you had a question about part-time? Is that what you were?
Well, my question is, does the full-time versus part-time status of a fire chief or a police chief, how does that influence the conflict of interest or incompatibility of office? If you have a large town, you might have a full-time fire chief. If you have a small town of 1,000 residents, your fire chief might only work 10 hours a week. But he still has the same responsibility and, in my mind, would have the same incompatibility factors, would he not?
So I think the question is right now, do we want to make this more restrictive or go with what's here? So I think that if you include part-time, it's going to be more restrictive. Is that what we want?
I think Representative Spilsbury's assent to removing full-time, which is what I understood you to say, that's the direction that I would personally like to go in.
It's a judgment call. My opinion, I defer to you. But I think part-time generally means 35 or more hours. Full-time means 35 or more hours. I think Representative Frack's point is fair. It's the function of running the department, regardless of how many hours you put in. I'd be perfectly okay with deleting those 3-4 words.
Okay, Representative Elwood.
Yes, I'm in favor of putting a period after the word department.
Okay. Thank you. So let's take a little straw poll on striking on full-time duty. So who is in support of striking that language? Looks like the majority supports that, so Representative Majority, could you note that? Majority.
So again, we're striking.
Okay. So I believe that we have beat row 1 to death. So we are moving on to row 2. So this has to do with the town clerks and deputy town clerks. So I'll start with Representative Gilman.
Thank you, Madam Chair. I'm going to go back to my question, which is, are appointed volunteer members of a planning board, historic district commission, facilities advisory committee, are they appointed? And if so, what is their conflict with a deputy tax collector?
So the subject of this provision, the way it was originally drafted, is town clerk, not tax collector. The object is to allow a town clerk to also be a tax collector. Or deputy town clerk was inserted in the amending process last year to respond to that flexibility that certain individuals representing the town clerks were looking for. So I don't know that it was not the original intent of the bill to preclude a deputy town clerk from having other positions in the community. It was the purpose to allow these town clerks to do multiple things, specifically in terms of elected or appointed tax collector, but not other things. I don't know if that fully answers your question, but I do think that the town clerk, especially when combined with tax collector, has a very broad range of authority and privy to a very broad range of inside information, and it's a very full job. And I think it's sound to say that person isn't going to hold a whole bunch of other positions.
So in the amended language that I'm offering for your consideration during this full committee work session, as you can see, there is a provision allowing for a town clerk or deputy town clerk to serve as a school district clerk, because we did receive feedback that people were concerned about that. So that allows that as a provision. And also, I felt that the amendment with regards to row 2 just made this section be more clear. So, Representative Spilsbury?
I think there are parts of your amendment that are helpful and there are parts that are confusing.
Okay,
I can target them very
please,
quickly.
thank you.
First, the change from may to shall, no problem. That conforms it with the syllogism of the other provisions. Second, I had indicated before, and I'll say it again, that I would have no objection to deleting the subordinate phrase, if authorized as provided in RSA 4145A, if it's the opinion of the committee that you're not limiting the combination of a town clerk and a tax collector exclusively to those situations where the community has voted to authorize it. I wrote the bill to say you could combine them only if the community actually took a vote to combine them. The town clerks are wanting more flexibility than that. They're wanting to be able to hold both positions even when they were elected as a town clerk and appointed as a tax collector. I defer to your judgment on that. If your judgment is the first, leave the bill the way it is. If your judgment is the second, take out that subordinate phrase, and no objection from me. I understand. But the word if means it's conditioned, right? Changing that to unless reverses the point. So you don't want to use the word unless. It says when you read it that way, it's no town clerk shall hold any other elected or appointed office other than tax collector unless authorized. But the unless is not the contrary position. That is the statute that authorizes combining town clerk and tax collector. So the word unless doesn't work there. It could be as, it could be if, or the phrase could be deleted. Any of those three would work. And then I think that the next sentence is not helpful and should be struck. And I think the third sentence is helpful. It addresses an issue that I hadn't thought of. So the second sentence, no deputy, that should be town clerk, not tax clerk, right? In the red language you've got, the word tax on line 4 should be town. Just a typo. So no deputy town clerk shall hold any other elected or appointed office other than deputy tax collector unless authorized as provided in 4145C. So I don't think that actually advances the bill. The third one, of course, the third sentence just simply says that a town clerk can also be a school district clerk. I don't see any objection to that.
So Representative Spilsbury, if my eyes are working correctly, in the amendment to 944H, it does say tax, wait, you're saying
We're talking about town
tax
clerks.
collector. Wait. I may have made a mistake when I prepared this side by side, so I think we need to revert back to the amendment because it appears as though I'm still trying to process this, that I made a mistake in the column for the amendment. So let's look at the actual unapproved amendment. Does that look correct? Yes.
I see. So
Yeah.
No deputy town clerk is correct
right.
in the amendment. That's right.
All right, so let's take each issue one by one. So you're okay with the shall,
Right.
and you have issue with regards to the words unless and unless.
I think unless gets it backwards. So either leave if in place or if you decide, delete the subordinate phrase.
So comments from the committee? Input? Yes. Oh, Representative Guthrie, I'm sorry, I didn't see you in the
That's all
corner.
right. I'm in the corner today,
Yeah.
so it's fine. I have a concern that we're saying that you're saying that the deputy clerk who isn't as busy as the clerk, the deputy clerk cannot serve on another committee. And I understand the rationale is that a person would not have the time and or expertise to do any other job. Am I correct or incorrect when I feel that way?
I think you're hitting a valid point. Originally, my bill didn't have the phrase "or deputy town clerk" there. It was just trying to preclude the town clerk. And your notion that the deputy town clerk is not as busy, has lesser responsibilities, is reasonably valid. I would point out, though, that there's another RSA that says when a deputy town clerk is appointed, that person has to be in a position to step into a vacancy with all of the powers and duties. So you could have a conflict arise if a vacancy occurred and the person was elevated.
When and if it happens? So when
You could
and if
resolve it then.
that happens, she becomes the town, or he becomes the town clerk.
Yeah. I have no problem with taking "or deputy town clerk" out insofar as limiting them from having other positions. This was a phrasing issue that was intended to accommodate the concern of the town clerks that either a town clerk or a deputy town clerk could also be appointed a tax collector.
It seems, if I may, Madam Chairman, it seems that we're taking the point of view that some people who are in a position cannot do anything else. And I know I have people in my town government, and I'm a selectman, that could are on 3 committees, because they can handle it. And sometimes this individual person is a deputy town clerk, but she's also happens to have the wherewithal. And I think we're determining, because people don't have the kind of wherewithal to do more than one position, that we're limiting what they can do. How come we're limiting what people can do if they have the wherewithal to do it?
Yeah, I think your comments are valid. If you just simply deleted or deputy town clerk, then there's no restriction involving a deputy town clerk.
So I feel good about that, but I think that's your general point of view, is that we should be looking at people who might have a lot of expertise doing 2 or 3 things, and you're saying that's a bad thing. I'm saying in a small government, particularly up in the North Country, it would seem to me that there are so few candidates that unless we let the town decide what they want to do and not have any restrictions on what they'd like to do, that seems to be the better way to go. So it's just how you feel about how you're going to run your railroad.
So it seems like we're working off of the amendment. So we're coming up with an amendment to the amendment. So with that reference point, what do we want the language for row 2, which would be parenthesis B of this bill? What do we want it to say? Representative Spilsbury? Oh,
I think your first sentence
yeah.
with shall is fine. I think the question on the first sentence is, do you want to allow a town clerk to be a tax collector only if the community has authorized the combination of those offices under RSA 4145A, or do you also want to allow a town clerk to be appointed as a tax collector?
And so the appointment would be by the select board.
Right.
So why would we not want to allow local control of the voters? I guess that's the question. What do we want to do? Do you want to give that choice to the voters to combine those 2, or do you want to give that to the discretion of the select board? So I obviously opted to give that to the voters. Representative McDonald.
Thank you, Madam Chair. I suggest that we, line 10, change to if authorized. In line 11, also change if authorized.
Okay, so that brings me to another piece of this, and that is we don't like the word unless, right? So the choice is unless, which we seem like we don't like. Another option is an as, and another option is an if. Is that correct, Representative? Okay, so Representative McDonald is suggesting that we strike unless and substitute that with the word if. So any comments on that? So if you support that change, can you just raise your hand? Okay, it seems like the majority is in support of that. So Representative Majori, could you indicate that?
Madam Chairwoman?
Yes.
So we're just keeping the language from the original bill, which says if.
Oh, we're working off of the column of the amendment.
Got it, okay.
Because that includes those, yeah. So yes, Get rid of it, get rid of the unlesses and put the ifs. My bad, my fail. Yeah, okay.
I think that completes everything on
Okay,
1B.
so, and then we're good with that row? Yeah. Are we good to move on to row 3 after representative majority? Okay, we're good to move to 3, okay. So 3's no changes, yay. But does anybody else have any ideas if they would like to change anything? So that would be the subsection C or subparagraph C that says no full-time employee or department head shall at the same time hold the office of selectman. Representative Rocht.
Thank you, Madam Chair. I will again raise the question of full-time.
Okay, we'll consider that. Representative Elwood.
Thank you, Madam Chair. I, too, object to the use of the words full-time, and I believe it should just say no town employee or department head shall at the same time hold the office of selectman.
Okay, we'll consider that. And Representative Guthrie?
Just to say about one if, what if a person is a full-time town employee in the Board of Public Works, say, but he's a laborer, but he's a real sharp guy and he wants to run for selectman? You're limiting his right to go for an elected office by statute.
So
I don't think you can do that.
Representative Spilsbury, do you want to comment on that?
Yeah, the prescription in this particular paragraph is to the office of selectman. So the question is, do you want a selectman who also derives his income, as an employee of the town? Do you want him passing on his department and his salary, for example?
Sir, I would say it depends on who the full-time employee is. I think if he's a laborer for the Board of Public Works, and that's the only example that comes to my mind right away because I know it's a fact that happens. And it's a young guy and he's very popular and he runs for selectman. You're saying he can't do that. And I don't think you can limit anybody from running for any office. Doesn't mean he's going to get elected, but I don't think it's right that we should limit anybody who can run for that kind of an office.
Thank you for the comment, Representative Guthrie, but we don't legislate laws for a single particular person. So you probably didn't, I'm very literal in your comment, that's what I'm hearing, but perhaps you didn't, you just cited that as an example. So I guess furthermore, if that laborer on the Department of Public Works, if they also ran as selectmen, then selectmen oversees the Department of Public Works. So that's an incompatibility to me. So any other further comments with regards to row 3 here? Okay, so what we have in front of us is to strike full-time to eliminate that. So if who supports that change? Okay, we'll go with that. So, yeah, moving to row 4 of the side-by-side. The only change that was made is the insertion of town administrator. So
Madam Chair,
maybe,
and of course,
yes.
I think that's simply a clarifying,
Yeah.
no problem at all, because it was meant that town modified manager and administrator. I think your
yeah,
addition makes that more clear.
Right, because obviously when I first read it, administrator, I took that to mean something else, and I wanted to include and be very clear that a town manager and a town administrator are two separate
Your change
positions.
aligns with my intent.
Yes.
Thank you.
Representative Davis.
Thank you, Madam Chair. I'm going to make you mad because I'm going to go back to the comment that Representative Guthrie asked about the laborer. If we are changing the title of this bill back to what it is in statute, incompatible offices, a person who is a laborer in public works does not hold an office. He has a job. She has a job. So what is it that we're talking about? We're talking about people who have a job in a certain department can't hold an office in that municipality. Is that what we're saying? I think we have to be very clear about our language with respect to people and their responsibilities and what they do, because this says offices, and someone who works for a town or a city does not hold an office.
Thank you for the your inputs, Representative Davis. But clearly, selectman is an office. So are you suggesting that we need to go back to row 1 and change the header of 669.7? I'm not sure what the remedy is here. And also, just help me to understand, with regards to a person who's an employee of the municipality, at the same time holding the office of selectman, who has authority over that department for which the same person is an employee.
Yeah,
Is there
I think
an
I'm
issue
not,
there
I'm
or
not
not?
speaking to the potential conflict of interest or concentration of power, any of that stuff that is the bill's intent. I'm just talking about wording and being very, very exact and careful with our wording so that we do not eliminate categories of people from serving in public office who may wish to do so. Even though they are not officers already, they're employees.
So would they not? I'm still seeing an issue here, but I'll let Representative Spilsbury comment and hopefully provide some clarification and understanding.
I think it's a bit of a semantic distinction, but a legitimate one. Incompatibility of offices implies a couplet that doesn't work. If that's a hang-up, I can see two ways of resolving it. Incompatibility of positions neutralizes it, right, to include an employee. Or simply go back to the header that was used in my bill, which is municipal office limitations, which does not imply a couplet. And it just, basically the limitation is on who can be a selectman.
Representative Walker.
Thank you, Madam Chair. In Rochester, we don't let municipal employees run for city council. If they do, then if they win, they resign from employment of the city. Because that's an incompatible situation, have a laborer in charge of the government that would be in charge of his own salary and in zones. That's not a good situation.
And I agree with that. And my issue is not with that, because I think that's the appropriate thing to do. My issue is with the title, the header,
We have that built into the city charter.
as do we, but this bill does not.
You can go, a municipal employee can go to the school board and run in the school board, can't be in the municipal government.
I do understand your point, Representative Davis. So let's just put that on hold. Representative McDonald, somebody over here had a comment? Okay, so it seems like, do we want to go back and amend the header? All right, so those who feel that it's fine, could we raise our hand? I mean, I'm neutral. So incompatibility of offices. All right, so for people who think that it should be something different, could we have a suggestion? Representative Davis, do you have an idea? Or incompatibility of positions, is that sufficient? Is that better?
I don't think so, because I don't think it's the legislature's responsibility to speak to the compatibility of positions that may not be within our purview. I don't know what an alternative might be.
But Representative Majori.
Could the alternative be just to make it another Roman? I mean, we'd have to, renumber it, but could it just be Roman 2 and that be its own category? No town employee or department head shall at the same time hold the office of selectman.
So Representative Majori, seeing that we struck the Roman here, and I believe in the current RSA that there's no sub-paragraphs, A, B, C. It
Okay.
is Roman numeral 1, 2, et
Okay,
cetera.
yeah.
Were you saying that then, and this might be a good idea, is to change the parenthesis A to Roman numeral 1, change parenthesis B to Roman numeral 2, and so on? Is that,
I mean,
does that help, Representative Davis?
yeah.
Yes, let's do that then.
So
And then it
all,
better mirrors.
so all letter references become
Roman
Roman
numerals.
numerals.
And then when we get to Roman numeral 2, 3, 4, 5, we're gonna have to, OLS is gonna have to
Yeah, I
just
don't know.
bump those up.
Makes sense.
Yeah, okay, let's proceed that way.
Madam Chair, one clarification then, that I might have it wrong. So when we changed Roman 1 to incompatibility of offices, that's not Roman 1.
No. So
Okay, I didn't-
incompatibility of offices is the header to 669
Is
colon
the
7.
header. Okay.
Right.
Got it. Thank you.
So I think that we've concluded that row of the side by side. Which row are we on now? Wait. No, we're on 5 now, correct? Okay, let's take up 5. Representative, all right. So just hold. So as you can see, so that allowed a selectman, I think, as Representative Walker may have commented, it's permitting them to serve on a co-op school, as a co-op school board member. Representative Grund.
Okay, if we're talking town versus schools, separate legal entities, they do not see anything over each other. There's no power over each other. We should not be dictating. They cannot be on both. If someone wants to run, they run and they get elected.
So if I'm not mistaken, some school districts fall under the town and it's not a separate district.
But mine doesn't.
What-
And
what-
you would be eliminating my town from people being able to run.
Could you repeat that?
So my town,
Yeah.
Amherst, we're separate legal entities. In fact, we have a lot of, so, and the town selectmen do not oversee the school. So someone should be able to run for both. We shouldn't be able to stop. That should not be in there.
So Representative Spilsbury, that appears in the bill as drafted, correct?
Correct.
So could you comment on that and compare back to current RSA? What's current RSA?
Yeah, let me just look at current statute here. So it's interesting comments about them being separate entities. That's clearly true. In 3215, the composition of a budget committee, which is voted on by the municipality, includes a member of the select board, but it also includes a member of the school district if the school district is subsumed within that one town. In fact, if a town has multiple school districts, then there's one from each of them, right? And so that doesn't really go directly to this question, but it does show that you've got a statute that's dealing with both the role of being a selectman and the role of being a school board member of a district subsumed within that town. I don't know that you can't do that. I think it's a judgment call. I thought that the distinction that the chair's made in this amendment makes sense. Certainly, it makes sense to carve out a cooperative school district, and I think the question that you're asking is, should you separate all school board positions?
Representative Grund?
Again, separate legal entities we don't have a budget committee. A lot of small towns don't have budget committees. We have a finance committees, ways and means committees that are appointed by the moderator. Those have nothing to do with selectmen, select board. Again, the select board doesn't oversee the school. There's no budget committee that oversees,
Sure, and I understand that. I referred to that simply to indicate the legislature's power to address both those roles in a single statute in terms of how they interact. But I understand your town doesn't have one. Sure.
legal entities that do have no power over each other, do not oversee each other. They should not be in conflict.
Representative McDonald?
It appears that this is going to be in conflict with some of our other communities and the way they manage their affairs, both in the school and in the town. So I'd like to make a motion that we strike that particular paragraph. No selectman may serve as a school board member serving the same town as a member of the school board. Accessors elected pursuant to number 5, I guess we're on.
I'm okay with that, but you also have the Board of Assessors there at the end.
Well, that was in the bill. That was in the bill as you filed.
Mhm.
So how would you like to handle this?
Well, I'm just understanding that the suggestion is to delete that
Okay.
portion of the paragraph that says,
Okay. Could you read how it would read?
so you delete starting the word either. Either a school board member serving the same town except as a cooperative school board member, or delete that phrase. Now it would read, no selectman may also serve as a member of a board of assessors.
Yeah. Yes. So are we Representative Grund?
Okay.
So that's the suggestion. Who supports that?
Can you repeat it again? I'm sorry.
So we're striking the words either a school board member serving the same town or a. So then that, it's going to become some Roman numeral, but right now it's E. So therefore it would read, no selectman may also serve as a member of a board of assessors elected pursuant to. Okay, so we're good with that. Moving on. So I'm looking at the clock and it's noon, and I'm hopeful that we can push through this. And at that time, we can take our lunch and then come back and exec bills. So that would give OLS time to draft an amendment to this. Is everybody comfortable with that? Representative Gilman? What? Could you, I'm gonna try. I'll reassess, you know, we'll see. I'm going to reassess, as we approach closer to 1 o'clock. Okay. So we're on row 6. Yeah. So there was no changes in what my amendment?
But I do have a question.
Yes.
So at one point, we add finance director or equivalent position in line
In row
1.
1, correct.
So I'm just doing this on the fly. No official handling funds of a town shall at the same time hold the office. So should the language be similar? Official handling funds. I agree. My only question is, we were very specific. We said finance director or equivalent position. I just curious about having equivalency of language. That's all.
So Representative Majori, you're suggesting to use the terminology official handling funds and substitute that for a finance director?
That's my question. Yeah.
Or the other way around?
I don't,
Okay.
I just don't know if it's gonna create an issue.
Yeah. Representative Walker?
I don't want any official in the finance department being an auditor. So I would say anybody handling funds shouldn't be auditing those funds.
Agreed.
I
So
think
what
this paragraph
Representative
and A are compatible.
Majority, he wants consistent language throughout this bill. So he's suggesting that we take official handling funds of a town and put that into row 1, where we were making the change in terminology to include finance director or equivalent position. Just so you see what we're saying. So he's taking the language in that subparagraph and inserting it under A.
Because I'm agreeing with you, Representative
Yeah.
Walker, completely. I just want to make sure that our language is very clear in all aspects to effectuate that point. That's my only thing, is just to make sure that all our language says the same thing. And maybe I'm kicking a hornet's nest that doesn't need to be kicked. I don't know.
Representative Spilsbury, do you have a suggestion?
My sense is I would leave it the way it is so that F can intentionally be broader than specific named positions.
Okay. Representative Elward?
What about the use of the term fiduciary?
We'll hold that thought. Representative Grund?
Yeah, so I agree that I think this should be left alone because handling of funds, I mean, you might have like a finance director, but you can have people who are actually running the checks, people who are actually doing, so I have to agree. I think this needs to conflict of interest. If you're touching the funds,
I mean, you could
don't
even
audit-
go
you
further
don't
and
audit
say,
the fund.
no one who lives in the community should be the auditor.
Who's recording them and who's depositing them versus who's paying them can be.
Representative Frocht, do you have a comment?
I agree that no changes are needed for row 6.
Thank you. So I'm going to propose that no changes for row 6 of the side-by-side. All those who support that? Okay, thank you. Moving on to row 7. I inserted school district clerk since the position is an elected position. Is everybody in agreement with that? Representative Frocht?
I thought we're just dealing with municipal officials, and a school clerk is, to my knowledge, is not a municipal official. It's a school official. Is that correct?
I believe that would be correct. Any
So
other comments?
I would suggest striking school district clerk.
Representative Grund?
So my thoughts on this, we're getting to the nuances, you're also saying, you're talking about the supervisor of the checklist. So I know it's not, this isn't overseeing school clerks, and maybe something needs to be inserted where schools are talked about. But if you're talking about supervisor of the checklist, then you are addressing a municipality role. So it
So,
could reside in two different places or something, like that's just where my nuance, I mean, this is why this is so hard, because there's so many nuances of what you're addressing.
so, the only thing in the amendment that was added was the school district clerk, so I'll, revert to Representative Spilsbury to speak to his bill as filed compared to the, current RSA.
So let me be careful here. My bill follows the current RSA, except that it adds deputy town clerk. The current RSA reads, no selectman, moderator, town clerk, or inspector of elections shall at the same time serve as supervisor of the checklist. I would agree that adding school district clerk is extraneous. Otherwise, the only difference between this and current law is deputy town clerk.
Any, Representative Murphy?
The deputy town clerk is usually appointed by the town clerk, so therefore it's not even an elected position at all.
Well, that's true, but there are numerous appointed positions that are referred to in this bill and in current law.
So does the committee want to keep school district clerk or strike it? Okay, so those who want to strike school district clerk indicate, so that's pretty unanimous, so we're striking that. And then are we good with that? Okay, I think Representative. Okay, so we're good, I think that we're settled on that, and we'll move to 8.
Bubbling down, they're saying any member of the town government shouldn't be on the finance.
So the purpose of this was to clarify, as you see in the comment, to clarify and simplify the language. And also to include an advisory finance committee, because that's an entity, as well as an official budget committee. All right, Representative Grund.
Thank you. So this is saying that members of, let's say, the school board cannot be on the town finance committee, and the town, and like a selectman or someone cannot be on a school district, like Ways and Means or advisory budget committee. When they have, again, they don't oversee each other, have nothing to do with each other. They don't set the budget, they just give advice. So considering they're separate legal entities, I think that they can be separated. That you should be able to, you shouldn't be on one for, like, if you're on the school board, of course, you can't be on a school board Ways and Means. I think that's absolutely fair, but there's no reason not to be on the town one.
So that's a consideration. When I put it in, I originally read it as an omission, and thinking that some people might not realize that there's an advisory FinCom financial committee and also budget committee. So that was my thinking, but I'm open to change. Representative Elward, did you have a comment?
Yes, thank you, Madam Chairman. I believe that we need to be consistent and eliminate the words full-time and part-time.
So Representative Spilsbury, what's your inputs
Okay.
with regards to these?
Thank you. I guess as a preface, I would point out, if you jump ahead to the top of page 3, you'll see that this amendment eliminates subparagraph 1K. And the reason for that is because the chairman's amendment has rewritten 1H in a way that basically subsumes 1K. She's combined both points. Okay, so I think that it's a good idea. I like the way you've rewritten it so that you've clearly delineated the advisory budget or finance member under RSA 3224, and you've also addressed the formal budget committee under 3215. Okay, that's good. I like that. I think that that combination of H and K and addressing each of those two types of finance committee is a very constructive improvement. On the question of the school district, I'm just going back here and trying to get the syntax right. So it's saying a selectman, town manager, town administrator, member of the school board, village district commissioner, full-time employee or part-time department head, ... cannot serve on the municipal finance committee. It's clear to me that 3224 and 3215 both involve the municipal budget committee. In fact, a school district's budget committee is authorized under RSA 195.
I go to the fact that, again, and it might just be where, understanding, like, my school board is and I think this goes with many smaller ones, is a completely separate legal entity from the town. So if I'm a member of a school board, is there not a reason I can't be on the Ways and Means for a town? Or advisory budget? 'Cause
Boy, that's
advisory
a judgment call, isn't it? But here's why I would argue that probably not. Because in a community where you do fully subsume the boundaries of the district, 32, 14, and 15 authorize the creation of a formal budget committee that will manage both the municipal budget and the school budget. Now, your town, you said, didn't do that, but it's allowed to do that.
Right, so then we.
And I think certainly in that circumstance, you wouldn't want a member of the school board on the budget committee.
Representative Grund?
Yeah, I would still strike out school board and maybe school district. I don't know what the right wording is there, where it says school district or village district. But I think you are immediately eliminating those towns that are completely separate legal entities from being able to participate in other town activities.
Representative Bajellobrick?
This is the first time I'm talking. Could you perhaps add that in there, but in maybe not so many words, except in towns where this, both entities are not combined, they're separate?
Can I ask you a question, Representative Grund? So, yeah, I do think that in the rewriting here, something's gotten confused, and we've now co-joined the idea of a full-time employee or a part-time department head of a school district. That's a problem. I would agree with you on that. Why should the mere fact somebody's employed by the school district prevent them from being on the budget committee? I think the point is a school board member shouldn't be on the budget committee that manages the budget of the school board.
Oh,
of the
100%.
schools.
That I agree with, but
Yeah.
this is basically saying I can't be on an advisory budget or finance committee. And so as a school board member, would I not be able to serve on the town committee? And our town committee is appointed by the moderator, Ways and Means. They are a finance committee is appointed by the moderator. They're not elected.
So you have an RSA 3224 advisory finance committee. And your school district, do they have a budget committee or finance committee?
Finance committee, they're advisory finance committee.
Two distinct entities, you know.
Two district, yeah. So
Um,
we'd have to, and I know we're not the only one out there, so that's why
Yeah.
I'm concerned of what we're hitting.
Well, I do think that Representative Grund has identified a valid issue here. We need to sort the language out. Can I do this on the fly is the question.
Representative Davis?
Thank you, Madam Chair. And thank you, Representative Spilzer. You just said, I think, the key words. We can't do this on the fly. There are so many nuances of language, so many, as others have said, moving parts here. And so many, as you yourself have called them, judgment calls. But they're really not judgment calls because in some municipalities, these things are separate and in some they're not. So that's not a judgment call, that's a fact. And I'm just wondering if we can solve all of these issues that this bill presents and the amendments that have added to it today. I think crafting legislation on the fly is probably not a terrific idea for the bill.
Thank you, Representative Davis. So that is the purpose of this full committee work session, is to work through this. We voted to retain the bill, and we're working on it. Some things can't be done in 5 minutes. That's why I provided a starting point for discussion. I'm confident that we can get through this. I would like at least to try. We have several hours here left in the day. Representative Spilsbury.
I'll take a stab. Representative Grund, would it work if the words were struck after the phrase full-time employee or part-time department head of the town, now then strike school district or village district or other associated agency? So the phrase I'm proposing to strike, school district or village district or other associated agency, does that solve the issue?
Not 100% sure it does, because even, let's say, one of our selectmen is appointed by the school district moderator to be on our Ways and Means Committee. Again, separate legal entities, and even 32:24 says no such committee's recommendation shall have any limiting effect on appropriation. So it's a selectman on a school board, separate legal entities, they're giving advice, but there's no reason why they shouldn't be able to give advice on, as a finance committee member.
I would concur that a selectman could be on a school district budget committee. That's what you're getting at.
That's one, but then
Yes, I
a
would concur
school
with
board
that.
member could be could be appointed by the town moderator to be on the Ways and Means for the town.
An at-large meeting of an advisory finance committee.
Again,
But
they're not a budget committee, so they're just giving advice to the rest of the town on the budget the selectmen are putting together. So if I'm a school board member, could I not be on a,
Well, so I think that if you delete the phrase that I just identified, then this is not talking about school district budget committees or advisory finance committees. It's talking about the towns.
it says member of school board. So it's just saying, you're saying this only addresses school board, because it clearly says member of the school board, and would say cannot be on, says no, so let's,
So I was
I would
trying
say
to,
no member of the school board shall serve as an advisory budget or finance committee under RSA 3224. Why not?
you're suggesting that just be peeled out as a separate sentence?
No, I think school board should be eliminated from, I don't see why school board can't be on a town advisory budget or finance committee under 3224.
Okay, so 3224 raises one question, I guess, and 3215 maybe raises a different question, right? Because I think 3215 itself indicates the way in which one member, selected member of the school board will be on the budget
Right.
committee. And I would think you don't want to have more than that one.
Right, and that's a budget committee
So,
versus,
so just to narrow the focus of your point, you're getting at 3224 and you're not addressing 3215.
correct.
Mhm. So what you could do, how about this? You remove any reference to member of the school board, school district, or village district from this sentence. You construct a simple new sentence which says that no member of the school board may be a member of a committee that has authority over the school's budget.
I agree with that.
That would work, right?
Yeah, and I get under the RSA 32:15, I do understand that piece.
Yeah.
Yeah, I mean, yeah, you should not be a member of your own
Right.
finance committee. You already have a voice as a school board member. Or
So
as a-
I think we can work that out here.
Okay, so could somebody come up with some language? I hate to
member of
ask the
their own.
question, but do we need to deal with full-time
Part-time.
and part-time? Do we need to strike that to be consistent? I see some nodding heads. Representative Murphy.
Yeah, in towns that have a budget committee, a 5-member board, 3 are elected, you have 1 appointed from the school board as an ex officio member and 1 member from the Board of Selectmen also sitting on that, and that would prevent that from happening, from what I can see.
I don't believe that to be true, that would still be allowed under other statute. The ex officio is permitted elsewhere in statute.
So under 30, you're right. 3215 says you can have a budget committee of anywhere from 5 to 12 members, right? And it specifically requires that there be a member of the select board, and if there's a school district within the town's boundaries, a member of the school board. This wouldn't change that. And that's, I think, the point of the distinction that we were just making, because that's 3215. We don't want to change that. But as to 3224, I guess the point that's being made is to allow a school board member to be on an advisory budget committee. It's not otherwise restricted. Does that address your question? So I that wouldn't be compromised.
Representative Elward, did you have a comment? So did you have a follow-up, Representative Grund?
Yes, maybe some wording could just say, no selectman, town manager, town administrator, member of school board, et cetera, et cetera, et cetera, or other associated agencies shall serve on their respective town or school advisory budget or finance committee under RSA 32:24.
Could you repeat that so
you-
Representative Majori can write that down?
Talk about on the fly.
So for H, I basically kept the same language. You can take out the full-time, part-time. That's something we can talk about, which I think is probably where we're headed. But where it says associated agency, So line 26, shall serve, I said shall serve on their respective town or school advisory, budget, or finance committee. So trying to say that if you're on a school board, you shouldn't serve on your own advisory committee. And that's under RSA 32:24 specifically. And then you can break out the,
Represent,
yeah.
have
So
input to this?
basically, I'm not striking a whole lot. I did take out the full-time or part-time for department. But on line 26, you see where it says associated agency? Yeah. And I said, shall serve on the respective town or school advisory, budget, or finance committee under RSA 32:24. So it says no selectman or no school board shall serve on their respective town, school advisory. Does that make sense? So if you, that, right, that's all I was trying to do. Yeah, that work?
Yes.
We still at it?
Did you get that, Representative Bonjori?
I think I got all that, yeah.
Okay. So moving on to row 9, when, in my opinion, when I read this, I found it very confusing. So, I thought I clarified things. Comments? Representative Fracht.
A selectman, by definition, is the ex officio member on a planning board.
There are selectmen that are ex officios, so there's some problems here.
That's my point.
Representative Spilsbury?
I'd identified the same reservation. There is a provision that comes up later that, where is it? It's line 14 on page 3. This section shall not prevent a member of the governing body from serving as an ex officio member authorized by law on any committee over which the governing body has supervisory responsibility. So that does address this, but the way that this provision is in my bill 488, it's talking about a municipal employee working in a capacity that provides support. So it's like your land use director, right? A subordinate employee. In the revision that the amendment makes, by bringing in selectmen, I'm not sure that advances anything because it's already addressed by statute elsewhere, right? So, yeah.
So you would say
One way or
that,
the other, it's either we don't bring selectmen into this or we specifically say other than as authorized in RSA 673, whatever that.
so we like to keep things simple and clear. So what I hear is that the insertion of or inclusion of the word selectman is redundant,
I think so.
and so strike it.
I would go with the original language in the bill in column 1.
Okay, and can we also include Conservation Commission?
I think that's valid because it's not under RSA 673.
Representative Colby?
Thank you, Madam Chair. I'm having trouble with some of these statements, and I don't know if that's why I'm humming and have a headache. But I'm thinking, we're not really stating here that, and very important is within the town that they're serving, right? So this, to me, reads that if I happen to be a DPW worker, that I may not be allowed to serve on my local land use board or conservation commission. We are not establishing that this is for the same municipality that you're working in. And I think that is a huge problem and will create massive amounts of questions.
So point is well taken, and I think that you would agree that that's the intent, not to prohibit what you're, if you're a resident
But
of a
I'm not
different
sure,
town.
because it's outlined in some places and not in others. I'm concerned that it is not the intent.
No, maybe I didn't express myself well, Representative Spilsbury.
Yeah, my question, Representative Colby, would be, does the language in the bill, in column 1, does that work? I mean, doesn't it? The subject is a very specific municipal
Hesitate going
employee.
back to number 1.
Column 1, right? It's only dealing with a municipal employee who is working in a capacity that supports that land use board.
But it doesn't say that. And in other places, we've identified serving the same town, serving of the same municipality. And in some of these, we are not using that identifying word. So one could read into that as saying, oh, this also includes my own hometown, because it is not specified as it is on these other items.
So Representative Colby, could we add that language to clarify that?
I think it would have to be
Yes,
added
and
under
that's
every
what-
single, yeah.
So it sounds like we're,
Well, I'm not following this. If you're not a resident of the community, is that what you're getting at?
No, I'm saying if you're a resident in your own community, if I am a DPW worker in Bow and I go to my house in Hopkinton and I would like to serve on the Conservation Commission, I shouldn't read the statute and think to myself, well, maybe I can't. But because
So that's why the phrase of the same municipality is here.
but it's only appearing under certain, it's not under every, it's not under 1K, 1H, it's missing under certain ones. So under 1C, no full-time town employee or department head shall at the same time hold the office of selectman. Well, does that mean I can't run as selectman in my own town? And the only reason I ask that is because if you go to E, you specify serving the same town. If you go to I, you've specified of the same municipality. So without continuity of language, I think we are going to raise questions that are unintentional.
so we could insert that clarifying language throughout. But let's put that on hold for 1 second and let's focus on 9 and finish up on that, and then we'll take up the other thought. So it sounds like we're going to revert back to the language under 488 for row 9, but then add on or Conservation Commission established under RSA 36A. So combining both. Does that make sense? Representative Gilman, do you have your hand raised?
Yeah, it might be simpler
Mhm.
to just avoid the same municipality thing altogether, because under 673(1), the establishment of local land use boards expressly says members shall be residents of the municipality.
Representative Elwood?
Thank you, Madam Chair, but I have a situation and would like to know the representative's take on it, given this language. We have a elected land use board member who is now serving as the clerk to the planning board, which everyone thinks is a horrible conflict of interest. And when I read the original bill language, so she's a municipal, she's, as the clerk, she's paid as a municipal employee. Which comes first, being the municipal employee or the elected land use board member? And how does that situation get addressed in this language?
I think the way the language is drafted, it would prohibit what you've just described, because that person is a municipal employee working in a capacity that provides support for a land use board.
Right, okay,
So
thank you.
I think that's a perfect example of what this is designed squarely to hit.
You're absolutely right, thank you.
So amended language for this section?
Well, I
Yeah.
liked what you just suggested. Go back to the
Can-
bill language and then add the second sentence.
You got that? Got it. So everybody's good with that? Is that correct? Yes? Raise your hand. Okay. All right, moving on to row 10. What was added was a zoning board of adjustment because the ZBA oftentimes approves variances and other matters decided by the planning board. Comments? Representative Walker?
Well, in my community, it is a city, but the city manager has a pick on the planning board. And we have a lot of city employees that potentially could run or not run, but get appointed to the planning board and the ZBA. We don't let them mix. In other words, a planning board member can't be on both, because you're approving what you did on the planning board, which is not a good thing to do. So I don't know how this applies to towns, but we do allow it in the city.
Representative Spilsbury?
Yeah. Could you clarify that? You're allowing what? Somebody who is,
The city manager has a pick on the planning board. So it could be a city department head, could be anybody. Normal employees of the city apply to be on planning board and ZBA. I don't know how that is much of a conflict, but
okay, so your question is, should someone who's on the planning board also be allowed to be on the ZBA?
no, that's a no-no. We don't allow
Yeah,
that.
that's definite. No.
You don't,
That's an appellate judge
Correct.
ruling on the lower court.
that's getting two bites of the apple. You don't want to do that.
So Representative Walker is asking about the bill as introduced to the committee. He's asking if that language should be changed.
What's the problem with municipal employees or department heads serving on either the planning board or zoning board, or not both?
That's a very interesting question, because it is illustrated well in my community, where we have had as many as 4 department heads simultaneously on the planning board. The planning board already includes an ex officio member of the select board. It basically means the town insiders are dominating all of the decisions. They actually have a majority vote. I don't know that that's true currently, but it has been true in recent years. And the whole concept of a planning board is to bring in additional eyes and ears and, think objectively about the various things that come before a planning
Follow
board.
up? But in some
And the
towns,
selectman is the one who is, in city may be somewhat different, but the idea that there be one voice to bring continuity over and to create a tie between the planning board and the select board, I think is a very good concept. It's these additional seats that start to shift the balance.
but the problem I've seen on email that came to me is some towns are so small, they don't have a lot of, a pool of people to pick from, so it happens to be the municipal employees that fill that role.
Was that objection coming from constituents in a city? That doesn't sound,
No, The city, I don't think a city has a problem with that.
Yeah,
It's written,
I mean, I don't think is a town obligated to have a planning board?
yeah.
I think it is. I don't, I'm not sure, but in any event, the concept here is simple, that one intertying voice is good. But if you start to get into a situation where you effectively have what the Securities and Exchange Commission would call in corporate America interlocking directorates, it's not good.
Representative Colby.
Thank you, Madam Chair. I think this is a great example and another example of why we need to delve into this further. I have submitted about 15, 20 minutes ago with OLS an amendment that would change this bill into a study committee for the purposes of going deeper and deeper. And also with all of these changes that we are making here today, even if we were to go through line by line to the end, we are still denying people from being able to weigh in as to whether these changes work for their communities or for their organizations or the people that are employed. So I would just like to bring that to your attention that something has been filed with OLS.
Well, thank you for that information. We are currently in a full committee work session, and we will continue to fulfill the purpose for which this committee was convened here today, and that is to work on this bill. I am not going to abandon it at this point in time. You, as you have done, are completely free to file an amendment. And during the executive session, the committee as a whole will vote on whatever amendments are offered to the committee. And thereafter, we will vote on the bill, either as is or as amended. So to also address your comments with regards to individuals being unable to offer input, this bill did have a hearing in the House, and stakeholders, individuals did have the opportunity at that time to provide public input, either in person or written. Additionally, this full committee work session was properly and duly noticed, and that stakeholders and people who had interest did have the opportunity to provide input to this committee, and we did receive input on various bills that will be exec today. So I don't really see anything at issue. Full committee work sessions are a function of a standing committee, and that's what we are here to do today. So with regards to this row 9, the language, Representative Majori?
Thank you, Madam Chair. I'm curious, Representative Spilsbury, I see why you put in, except as expressly provided in RSA 673-2, and I think it speaks to what Representative Walker was speaking about. So, Madam Chair, I look to you as your thoughts on removing that reference to the statute, because it not only applies to cities, but that reference also applies to towns.
So how do you want section J, which will be renumbered, how did you want that, how are you proposing that read?
Oh, I think that as it reads originally from Representative Spilsbury's bill, it addresses the issue that Representative Walker brought up about having appointees as permitted through statute. So my question is to the chair, just your thoughts on why you struck that in there to say now to be the planning board or zoning board of adjustment. Just trying to figure out which language makes more sense.
I would probably say that's an oversight. So you're recommending to include that phrase in? Is that correct?
Yes, I would recommend leaving it as originally stated.
I would certainly concur with that. I think that's wise. I think you could just simply take that phrase and put it back at the end of the sentence after the ZBA.
Okay. Representative Elwood.
And do we not need to strike full-time in front of municipal employee?
Representative Davis? Okay. So could somebody propose how we offer how this should be read?
Madam Chair,
Yes.
I would propose it say, no municipal employee or department head shall serve on a planning board or zoning board of adjustment except as expressly provided in RSA 673:2. And I say that more because that's what I'm going to write down.
I concur.
Yes, so I'll
Okay, so
allow
that's
you
what
to
I'll
write
write
that down. So all those that support and are in an agreement with that language indicate.
Okay, so 11,
Okay.
12.
Thank you.
It's 4 3.
So I see that the time on the clock, I feel that the rest of these rows are not controversial, so I'd like to push forward. So row 11 was that subparagraph was deleted because it was redundant language due to the fact that it was addressed back under row 8. So moving on to row 12, there's an insertion of no person shall file a declaration of candidacy for an elected office that is incompatible with a currently held office under paragraph 1. Comments on that? Okay, Representative Walker shared that it's common sense. Representative Grunt.
So quick question to Representative Walker. So one of the things if you don't mind, one of the things that he brought up earlier was that he had people who ran for office. Once they won the position, then they gave up their other position. This would say you can't even run?
That's correct. If you're currently holding a position that's incompatible, if you want to run for an incompatible office, then
You'd have to resign before.
correct, because it
Only
creates
if you want.
a situation.
That's not what this says.
What? So there's already in statute, it says that a member of a school board that's currently sitting on the school board can't run for the position of, now it might be a cooperative school board, because I know that's a specific example that I encountered. So let me just frame it in with that regard, but the point is still the same, that we have in statute elsewhere that a sitting member of a cooperative school board can't run for cooperative budget committee. Just hold on. So okay, that was not the intent of what I was trying to do, so thank you for pointing that out. My intent, I'm trying to explain, was that if you currently holding a position, you're in a position and you want to run for an incompatible position, you can't still be in that position and then run, and then you have an incompatibility, so now you have to say, oh no, I don't want what I just ran for, or you resign and then there's a vacancy. That's what I was trying to do. Perhaps the language missed the mark. Help.
With all due respect, I think it does, and I do think that it violates the state constitution because any person can run for any office.
But, okay, thank you, Representative Davis. So, yeah, I thinking about that, the Constitution does it not say that who's qualified for the office. So who was duly qualified, isn't that qualification? Aren't they derived from statute? So,
That's a question a judge would have to answer, but my guess is that if this bill were to be signed into law with this language, it would be, we'd be sued immediately.
well, thank you for that input. This is the purpose of a full committee work session, is that we can talk about this, change the language. Does anybody have any suggestions? Representative Gilman?
Well, I raised my hand for another point, but
Okay.
not for making a suggestion. There is somewhere in an RSA, and I will try to find it. I found it last night, but that if somebody is in an elected position and then they're not up for reelection, so their name only appears once running for a different position, then they choose, they step down from whichever one is in conflict.
After they've won?
Yeah.
So do you want to strike this? Okay. That's fine.
Yeah, since we're already addressing the conflicts in the other pieces, this is not needed because you're going to have to resign, one or the other.
Because your election period is in November. You don't take office till January.
Yeah, that's a city.
Yeah.
Towns are different. So I'm happy to strike this. Is that what everybody wants? Raise your hand if you want it. Okay, got that, Representative Majori? Row 13, no changes. Comments on that? Representative Davis?
Thank you, Madam Chair. When I read this section, Roman numeral 4, it seems to me to be kind of extraneous to the bill, to the intent of the bill. And I'm hoping, Representative Spilsbury, that you can enlighten me as to why it's even here.
So just to clarify, you said Roman numeral 4. Did you mean 4 or Roman numeral 3? Yeah.
I meant 3. I'm sorry.
Okay, that's what I thought. Representative Spilsbury?
Just let me read it carefully once again. So I have no particular opinion about it, but that is in current statute, unchanged. And so in the current statute in 669(7), that paragraph is Roman numeral 2.
Yeah, so we don't need to discuss that because that's in current RSA. So I think that we can agree that we're good on this. So moving on to row 14, I suggested to add in member, an ex officio member authorized by law to clarify. Are there instances where a member of the governing body could kind of appoint themselves? No? Okay. Representative Spilsbury?
It is specifically limited to, those things over which the select board has supervisory responsibility. I think it's a good supervisory tie. So I wouldn't limit it to, I would say any subcommittee they create, they can have somebody on it.
So to strike the member authorized by law.
Right, that's what I
Okay.
would do.
Does everybody like that? Raise your hand if you like it. Okay, Representative Majori, can we do that? Moving on to row 15, it's just a terminology change. The proper terminology is a regular member, not a full member. Are we good with that? Everybody good with that? It's regular member is cited in elsewhere in statute just for consistency. So moving on to row 16, I added until their elected term or appointed term expires, that will allow the person to finish out their position until the term ends instead of kicking somebody out. I thought that that was fair. Correct. I thought that was fair. Representative Grund?
So, yep, I get what you're saying, so I just want to, so if we have a selectman who's currently on a planning board, they're going to finish out the 3-year term or whatever they're like.
That's a suggestion. If you-
That was the intention, to allow for a transition.
Mhm. Representative Majori?
I think I'm arguing against, I'm arguing against that. If we create if this bill establishes that you are sitting in a conflict of interest, why would we let them serve out the remainder of their term? Am I hearing that correctly?
I would, yes, you are. And so, to be clear, I believe that the thought behind what this was to allow for a transition, because if the person gets kicked out, now you have a vacancy. So it's just,
There is a fine point that
Okay.
needs to be stressed. The difference between the bill as I drafted it is essentially a vacancy occurs at the next election. So let's say you have somebody who's in a 3-year term. Basically, that position would open up at the first election and not have to wait for the 3rd year.
Madam Chair, follow up my own question. I would support that. Otherwise, to let somebody serve out 3 years in a conflict of interest, just knowing me and I'm a little snarky, I'd have fun with that.
okay, so we want to strike. Yeah, so I was being too nice, right?
I think it needs to be more draconian.
Okay. See, I'm trying to be nice and it doesn't work out. Could you read how that's going to read? Okay. Good. Everybody good with that? Yes. Representative Colby?
What would you do for the appointed boards?
Representative Spilsbury?
I suppose, so let me make sure I understand. Your point is that they're not subject to elections, so are you waiting artificially for the next election? Or does it become vacant immediately and subject to reappointment?
Correct.
Good question.
Representative Gilman sounds like she has a suggestion.
I do. Can we just add, we're going to use the original language, but yeah, it's good. It's a good point, and I want to put it in there somehow.
How about something like
Next election or appointment?
election, of course, relates to the elected positions. So say, or in the case of an appointed position,
A
within
reappointment.
within 60 days.
Okay.
Yeah, or appointed term expires. Just add that on the end.
Representative Elwood?
So should it not read members of boards and committees holding elected positions may remain in those positions until the next elections are held, and then the appointed language. So get rid of conflicting and put elected positions.
Representative Davis?
This bill also puts employees in a potential conflicted position. And I don't recall seeing any provision in the bill, correct me if I'm wrong, about what they should do regarding their employment versus their election or appointment.
Let's just put that on hold. Representative Frock, are you going to say the same thing?
Sort of. I would argue that because boards have alternates
Mm.
and there are specific RSAs regarding filling vacancies on boards. If a situation would arise, for instance, as Representative Stavis posited, that a member of the planning board took a job with DPW, that at that point, the member, or the person would have to leave the planning board, and the normal procedure for filling the vacancy would then follow through, rather than waiting for the next election. Just my thought.
Representative Walker?
On the town level, when there's an appointment on the board, do you appoint for a term or is it an indefinite appointment?
Appointed for a
There
term.
are actually a lot of statutes that state that differently, but what I think is the most typical is that someone as soon as the vacancy occurs, the selectman can make an appointment not for the entire balance of the term, but to the next election. So let's say you've got a 3-year position on the planning board. A vacancy occurs on the 8th month. Somebody is appointed to fill out the remaining 4 months, but in March of that year, somebody then runs to fill out the remaining 2 years.
I understand that part when you're an
Okay.
elected planning board.
Yeah.
But if you're just a appointed planning board, is it an appointment, like a 2-year or a 3-year term? Then I think that this statute, the same stuff would require. You serve out your term or you make a vacancy and an alternate takes your spot, period.
Representative Colby?
I would just urge us to remember that planning boards that are appointed and not elected are, I mean, this is typically done because there aren't enough people to go around that want to run for office. It is very common for people to change to a appointed planning board. And therefore, when you talk about alternates, they're alternates somewhat for a reason. They don't want to be committed to 2 meetings every month. So we can't just assume that the alternates that we have are going to fill a vacancy on a permanent basis. So I would just urge caution and tread lightly before we have empty land use boards.
Well, I would agree with that. So I don't think that this bill should step into the question of how a vacancy is filled. It should only address the question of when the conflict has to be resolved by foregoing one of the 2 positions.
So we've had a lot of input and feedback with regards to this particular section 2 of the bill. Does somebody have proposed revised language?
So isn't the question simply what triggers the vacancy, right? Not how do we deal with it?
If you trigger the conflict,
Yeah.
then you resolve it by, you're done, then you just follow your normal replacement procedure.
I agree with that. I suppose the only question from a transitional perspective is, do you want to make it necessary that one of the appointed positions be dropped on the effective date of the bill, or do you want to allow a transition further?
Well, I believe in
The next
statute,
provision does, the chair's amendment suggests that the bill take effect 60 days after passage. So maybe it's enough to just leave it like that and give people 60 days notice.
well, I think it's in statute for one of these appointed positions that if you're leaving, you're not replaced until another one's appointed for you. In other words, you can
No.
go a little bit further if there was still a vacancy. But once the vacancy is triggered, you go through your normal procedures, and part of that normal procedure is you're staying until you're replaced. That's your transition.
I am aware of a couple of statutes that allow for continuity, right?
Right.
But I don't think that's the norm. And I think the real question here is, it's this bill, if enacted, that will state when you have to give up one of the positions. So I don't think these other RSAs affect this question at all.
So I'm going to just quickly move to row 17 because that was invoked. I did change it to 60 days because pursuant to RSA 14-9A, it's prescribed as to when certain types of provisions shall take effect. So I didn't see any evidence under that statute as to why it should take effect upon passage. Therefore, I put the 60. We can check with OLS on that to ask their opinion. But let's get back to row 16. Do we have proposed language to amend that? We're almost done. Representative Spilsbury.
So this was touched on before. I think it was Representative Grund. If you put the word elected into this sentence after the word conflicting, I wouldn't take conflicting out. I mean, after all, the whole point is these are conflicting positions. But conflicting elected positions, then that's what this deals with. It deals with the situation of an elected position. You could then remain silent regarding an appointed position, or you could add a very brief phrase that says, or in the event of an appointed position, on the effective date of this bill.
Representative Gilman, did you have any, could you contribute, because you had some ideas with regards to the wording? So I think what I'm hearing is Representative Spilsbury said to, with regards saying committees holding conflicting elected positions may remain in those positions until the next elections are held? No, what? Held.
It's meant to be the very next election, not the end of the term, which
Right.
as
So we're getting
Representative Walker said,
rid
could
of
go on
end
years.
of term because that was a bad idea, apparently. Okay. Admittedly, we're getting rid of that. So the prime sponsor's intent was to next election. So could somebody, Representative Grund,
So a suggestion was made about when you swear in the next officer.
but swearing in is done with regards to elected positions.
No.
No,
No,
all
even
positions.
appointed, At
Appointed.
least in our
Okay.
town. Yeah.
Clerk swears them in, so once someone's sworn in, they assume the
Okay.
office.
So-
it's incompatible.
All right, so what does the committee think about that? Representative Davis.
I think it partially works, but the first part of it has to be that somebody has to step down. That something has to stop in order for that swearing in to take place. And what's the mechanism for that?
Representative Elwood?
When they become subject to this section.
Isn't that part of your reason for adding the 60-day delay before the bill becomes effective?
No, my reason for changing that was simply just following RSA 14-9A. Representative Colby.
I hate to, make more worms here, but what if on the effective date as amended by Section 1 of this act, members of boards and committees holding conflicted elected positions may remain in those positions. Okay. So what if one of my positions that I'm holding is elected and the other one is appointed? Does that, am I still
So you have to choose one.
So I think it should be elected or appointed positions in that first conflicting elected or appointed positions.
So Representative Spilsbury, what are your thoughts on that? Because you had,
I have no objection.
Okay.
Look, the idea is to change the law in the long term, and a transition is always okay, right? If we're going to allow for the elected officials to stay in office until next March, you could let the appointed officials stay where they are until next March.
okay, so we have to figure out what follows the word until. Until the next elections are held, until swearing in, what do we all want? Representative Walker.
I just think you follow your replacement procedures, period. Every board has alternates. They're not going to be there forever. They can be there until another one's appointed or another one's elected. But you have alternates for a reason. They should step down and follow your regular replacement procedures.
So I agree with that. That's extraneous to this bill. I think when you boil it all down, the language in the bill works.
So we revert back to House Bill 488, but
If we're not
add
making a
in
distinction
elected-
between elected and appointed officials, then I think the wording
Okay.
meets the needs as it is.
okay. Does that make sense to everybody? I think what Representative Spilsbury just said is just strike my amended language and just stick with House Bill 488 language for that section. Is that correct?
Sure. I think that's a perfectly reasonable outcome. Basically, elected officials, appointed officials are put on the same timetable.
I'm going, Representative Elward.
Regarding alternates, shouldn't, for example, in row 1, it say, no person shall at the same time hold any two of the following elected up or appointed offices? If we're, and alternates, how do we get alternates into this whole scheme? In other words, are alternates going to be holding conflicting positions while everybody else can't? Where do they fit into this picture?
Madam Chair, alternates or the duties of an alternate are prescribed in the article in the article before this, I think. I don't have it up on my screen, Died. But I think that because of that, it doesn't need to be added to this.
So just to be clear, we're done with 16. We're going to revert back to the bill language. We're going to put Representative Elward's comments on hold. And are we all good with line row 17 of side by side? I think we are. Yes. Okay, so the last thing is Representative, does anybody else have any comments with regards to the point that Representative Elwood made? No. So I think the conclusion is just no further changes are being identified at this point in time. Correct? Yes. Everybody in agreement? Raise their hand. Okay. So Representative Majori, you were the scribe.
Do you want me to go over what we've done? Do you want me to just write it down? What's the preference of the chair? By the way, I have 17 changes.
What does the committee want? Do we want to? I think that we very carefully went through everything, but it's whatever everybody wants. I trust Representative Majori. Representative McDonald, would you
Okay.
like to? Okay. So I think we're comfortable with that. We'll have OLS draft an amendment as a product of this full committee work session. Yeah.
Just process, Madam Chair.
mhm.
For myself, I'd like to just read through all this.
Okay.
Go through not only the original bill as Representative Spilsbury has presented, your amendments, make sure that I have it all right.
Okay.
What's our time frame on this? I mean, I'll do that.
All right,
I can do
so-
that tonight, but there's a lot here.
Okay, so the plan for today is that coming out of these work sessions, that we were going to have an amendment, because OLS says that they can produce an amendment in an hour. So,
We'll test it.
so we also need to have lunch. No, no. So let me, I think that's the way that I would like to proceed, because we did the work. I will sit with you, Representative Majori, and help put in that amendment. I think that we can do this without needing to come back another day. So that's what I would like to do. Representative Elwood.
I rescind my comment about alternates because it's addressed in column 15 or item 15.
Okay, thank you. So, just 1 second. So, I've conferred with the ranking member and the vice chair, and what we're going to do right now is we are going to take lunch, and we will come back here at 2:30. So, and at that time, we will exec these bills, and the hope is that OLS can make good on their claim that they can get an amendment in an hour. So we will be also working on that. Huh, right. Okay. So we'll see people back here at 2:30. Thanks. Okay, everybody, we are back in the committee room from our lunch. The time is 2:35 approximately. So during lunch, Representative Stavis, Representative Maggiore, and Representative Spilsbury worked through their lunch break, working on the amendments. So as a result, I will now close the full committee work session on House Bill 488.
Madam Chair,
Yes, Representative McDonald?
I'd like to call for Republican caucus.
Okay. How much time?
10 minutes.
So at this time, we will go into caucus. So Republicans will remain in this room and Democrat caucus will caucus somewhere. And so we will come back here at 2:45, which is 12:45. No, make it 12:46. Sorry. What? Yeah. Sorry.
Hello, hello? No.
So I'd like to thank everybody here in this room for your patience. This has been a very busy day, and with conducting the 2 full committee work sessions, it took a lot longer than I had predicted. To be honest, I thought that with the meeting and the full committee work sessions beginning at 9, I really thought that we were going to have a lot of downtime, and it didn't turn out that way. So, again, I'd like to thank everybody, the committee members, for hanging in and working so diligently to conduct our business. So at this time, I will open the executive session on House Bill 173 relative to maintaining the purpose of a petition warrant article. So do I have a motion on that bill? Representative Franz is acknowledged for a motion.
I make a motion for ought to pass on HB 173.
Is there a second?
I'll second that.
Representative Bejello-Brick seconds that. Discussion. Representative Franz, would you like to speak to your motion of OTP? Sorry. Representative Majori?
Thank you, Madam Chair. I'm going to be voting against the OTP. I don't like the idea that we're treating petition warrant articles differently than we are regular warrant articles, which can be amended. I think that what you're doing is you're taking away the will of the voters in a way that is that disenfranchise or potentially could disenfranchise them. So for that and other reasons, but that being the primary reason, I'll be voting against the OTP. Thank you.
Thank you, Representative Majori. So I would like to follow up on those comments. So the reason that this bill was filed is precisely because in what we're seeing, and I personally have heard from numerous state reps with regards to petition warrant articles in their towns and school districts, that in fact petition warrant articles are being treated like a second-class warrant article. So additionally, I don't feel that the language in this bill is prohibiting a petition warrant article from being amended. What it's doing is it's stating and clarifying and reinforcing the fact that a petition warrant article, like any other warrant article, the subject matter should not be changed. So the language in the bill states that the purpose of a petition warrant article shall not be changed. And what we're seeing is that, for example, if a petition warrant article, to me, once a warrant article is on the warrant, they're warrant articles. It doesn't matter how they got there. So what we're seeing is, for example, if there's a petition warrant article for a cap of some sort, that the meeting that's the purpose. It's a cap. That's the noun in the petition warrant article. And what's happening in meetings is that the warrant article is being changed into a study. And that's the noun, that's the purpose in that amendment of the petition warrant article. And that shouldn't be happening, because that is changing the subject matter. So I offer this explanation just to perhaps further understanding of what the purpose of this particular bill is that's before us. Representative Colby.
I find it very strange. The purpose of a deliberative session is to deliberate. To author a citizen's petition and then deny the voters an ability to deliberate and work cooperatively toward agreed upon terms or changes will add fuel to the fire that we heard about of fringe special interest taking over a meeting. Last session, our colleagues across the aisle here were very adamant that citizens petitions received equal respect and time as traditional warrant articles, and yet this bill is requesting special treatment of a citizen's petition by saying, if it's a citizen's petition, you can't change the purpose. But if it's a regular warrant article, you can change the purpose still, because it has not separated those two items. So I do agree with Representative Maggiore that the bill is requesting the special treatment and also denying the citizens the right to fully participate in their town meeting, their deliberative, and their democratic process. These types of warrant articles should not be treated differently. Thank you.
Representative Stavis is recognized for a comment.
Thank you, Madam Chair. I cannot support this bill either for all the reasons previously stated, but I would like to add an additional one, which is just the question of who decides. Who decides whether it's been changed sufficiently that it's not permissible? And that's not delineated in this bill. And that leaves a big question mark in my mind as to who does the deciding.
Further comments? Okay, seeing no further comments, the motion before us is ought to pass on House Bill 173. If you are in favor of that motion, you will vote yes. If you are opposed to that motion, you will vote no. The clerk will call the roll.
Vice Chair McDonald? Yes, please. Representative Guthrie?
Yes.
Representative Dolan?
Yes.
Representative Aylward?
Yes.
The clerk votes yes. Representative Franz? Yes. Representative Karasinski?
Yes.
Representative Murphy?
Yes.
Representative Walker?
Yes.
Representative Stavis?
No.
Representative Gilman?
No.
Representative Majori?
No.
Representative Frocht? Oh, excuse me. Representative Colby?
No.
Representative Germana?
No.
Representative Gerard?
No.
Representative Grund?
No.
Madam Chair?
Yes. The motion passes with a vote of 10-7. The committee recommendation on House Bill 173 will be ought to pass. And that will go on the regular calendar. And Representative Franz, will you write the majority report? Will there be a minority report? And Representative Colby will write the minority report. Thank you. Okay, so with that, I will close the executive session on House Bill 173. So next, at this time, the chair will open the executive session on House Bill 348 relative to the eligibility for local assistance. So Representative Karazinski is recognized.
Thank you, Madam Chair. I'd like to amend House Bill 348 with Amendment 2025-10154H.
Thank you, Representative Karazinski. Is there a second? And yes, I will second that. Representative Karazinski, would you like to speak to your motion to adopt the amendment?
Yes, thank you. We discussed this in the spring and, well, I guess it was the winter. But my town of Swansea's really been hit by this again this year. We have non-resident transients that find that our town hall is open during the day when a lot of the smaller towns aren't. And they stop in and claim residency and get put up in hotel rooms. We've seen our general welfare budget get surpassed every year these last few years. Last year was 240,000. This year's 280 was budgeted, and we are going to go over that. The city of Keens, I believe, $1 million. So I think everybody wants to try and help out the people that need help. But when you get to a certain size town and you have a town hall that's open during the week, there's a target on you. And I think our residency requirement would be a good thing to try and just minimize the impact to our town. And adding in the local assistant monthly limit of not less than 50% of the federal poverty level still makes it a pretty good chunk of change that we could give people to get them through. But again, it would be for residents, the people that have a tie to our town. And the other special consideration to provide non-residents with up to 72 hours of aid until they can prove their residency will help out also. Again, these are enabling, and it's up to the town to do what they can for the people that need general welfare. Thank you.
Thank you, Representative Karazinski. Further comments? Representative Colby is recognized.
Thank you, Madam Chair. I see because the language of the bill becomes problematic, that not only, I do understand that it's enabling legislation, but it's almost too enabling because it enables you to require different things from different people, not just different things within the town. The use of the word may, line 7, may require an individual to provide proof of residency. Special consideration may be provided to non-residents who have left their town of origin for domestic violence, sexual assault. So it's no guarantee that two people showing up to your welfare department are going to be treated equally under the same municipality. So while I do appreciate the enabling aspect, it's almost too enabling. There is no guarantee that the community you live in will support your basic human needs for food, shelter, or heat. And it will be different depending on where you live. So I think this could actually create a problem for places like Swansea or Keene, where if the policy you adopt is almost too humane, you're going to be opening the door for residents from other communities to come in and ask for assistance. Thank you.
Further comments? Representative Davis.
This is really a question. And I'm looking at the original bill and looking at the amendment. And in the original bill, in the RSA, providing public assistance is not a may, it's a shall. And I'm looking at the amendment, and it is no longer a shall. Is that intentional? The shall is written guidelines, not provide assistance.
To clarify, this amendment here is really focused on guidelines. It's providing a framework for guidelines that municipalities shall adopt. So it's a framework, and there's flexibility and leeway within these guidelines for that municipality to, I guess, tailor, if that's the correct word, their guidelines. So the amendment starts with Roman numeral 2, and it doesn't change Roman numeral 1. It says whenever a person. So this is not really about limiting assistance to those in need. It's about, it's really focused on enabling municipalities to craft guidelines as they see fit for their municipality in order to be able to provide assistance to the people that come to them who are in need. And furthermore, with these guidelines that will enable the municipality to be able to, I guess, more fairly distribute the resources to persons who are in need of local assistance. Further comments? Representative Majori.
Thank you, Madam Chair. In number 2, the governing body made its discretion to authorize local assistance, and it continues to go on for up to 72 hours to allow application and communication coordination with the town of origin. So I'm curious, if somebody comes in on a Friday and the following Monday is a federal holiday, 72 hours could lapse before the sending community has had a chance to review the application. What happens after 72 hours in that time frame? Because it doesn't say 70, it just says 72 hours, so it doesn't include business day, or it's not descriptive to business days.
So there's no obligation for any committee member to answer any question because this is not a hearing. And I'm just going to leave it at that. Further comments? Representative Karazinski.
Well, that being said, I would also note that if the subject or folks showed up on a Saturday morning, they would be out for 3 days with nothing. So, there's not a whole bunch we can do about the calendar.
Representative Grund is recognized for a comment.
Thank you, Madam Chair. Some things that were brought up before that I think still exist to this point today is that there are some people who cannot provide that proof of residency. And this would be detrimental to them receiving assistance. I'm not sure where these people are supposed to go, what they're going to do, but we're basically saying we're not going to do anything for you. See you later. I'm not sure that's the right answer that a town should be doing. I understand there's strain on town budgets, but what are they going to do? They're going to show up to another town, push them off to somewhere else. So I don't think this solves an actual problem. Thank you.
Further comments? Representative Colby.
Kind of piggybacking on Representative Grun's point, If I had to do this right now, I will be the first to admit, my house, my mortgage payment is in my husband's name. My lease for my car is in my husband's name. So all of our utilities are in my husband's name, and I know I'm not the only one. For better or worse, that's just how things ended up. And if for some reason I had to flee my home, I would potentially be denied service, as would many other women in a similar situation where you are not the breadwinner. So I would just ask you to really consider that. Proof of residence is not as easy as we think it is. Thank you.
Representative Guthrie is recognized.
Thank you, Madam Chair. Way back in the day, I was a welfare agent once, and it seemed to work pretty good. My question really is, what problem are we trying to solve? And if so, what does this do to solve the problem? What's wrong with the present system we have in place?
As a further reminder, this is not a public hearing, and you are not directing questions to somebody on the witness stand. So are there any other further comments with regards to this amendment? Representative Germana.
Madam Chair, if I may, I want to apologize. I didn't mean to make it a question. I thought I was making a statement.
Okay.
Thank you.
Your apology is accepted, and I appreciate that. Representative Germana.
Thank you, Madam Chair. While I can certainly echo, being from Keene, some of the concerns from the representative from Swansea, I just don't think that this piece of legislation is the one that really fixes all these problems. For one example, the governing body may, at its discretion, authorize the local assistance. It should just be the emergency assistance is provided if needed. The governing body isn't needed to provide discretion at that point. As well as the limit of not less than 50% of the federal poverty level. That's giving about $600 a month, which is going to last maybe a week in Keene. And it's just not enough for anyone to get by. So that's why I'll be voting no on this.
Further comments? Representative Stavis.
Thank you, Madam Chair. I'd just like to remind members of this committee that this committee passed legislation 3-4 years ago, can't remember exactly when, that enabled communities with large populations of needy folks like Lebanon, like Swansea, like Keene, to bill the sending communities. So we have, to a great degree, mitigated this issue. Now, I don't know if that's being followed up on by individual municipalities. If it's not, it certainly should be. But this committee passed that legislation a few years ago that enables towns to recover some of the expenses involved with providing assistance to the poor, which is mandated by state law.
Further comments? Okay, seeing none, the motion before us is to accept Amendment 2025-0154H to House Bill 348. If you are in favor of accepting the amendment, you will vote yes. If you are opposed to the amendment, then you will vote no. The clerk will call the roll.
Vice Chair McDonald?
Yes.
Representative Guthrie?
No. No.
Representative Dolan?
Yes.
Representative Aylward?
Yes.
The clerk votes yes. Representative Franz?
Yes.
Representative Karasinski?
Yes.
Representative Murphy?
Yes.
Representative Walker?
Yes.
Representative Stavis?
No.
Representative Gilman?
No.
Representative Majori?
No.
Representative, excuse me, Representative Frost is absent. Representative Colby,
No.
Representative Germana,
No.
Representative Gerard,
No.
Representative Grund,
No.
Madam Chair.
Yes.
9 to 8.
So the vote to accept Amendment 2025-0154H carries with a vote of 9 to 8. Do I have another motion? Representative Karazinski?
Yes, Madam Chair, I make a motion that we ought to pass House Bill 348 as amended.
Do I have a second? Yes, I second that amendment. Would you like to speak to your motion, Representative Karazinski?
I think we've spoken of.
Okay. Any other comments on that motion ought to pass with amendment? Seeing none, the clerk will call the roll.
Vice Chair McDonald,
Yes, please.
Representative Guthrie,
No.
Representative Dolan,
Yes.
Representative Aylward,
Yes.
the clerk votes yes. Representative Franz,
Yes.
Representative Karasinski,
Yes.
Representative Murphy,
Yes.
Representative Walker,
Yes.
Representative Stavis,
No.
Representative Gilman,
No.
Representative Majori,
No.
Representative Frost is absent. Representative Colby,
No.
Representative Germana,
No.
Representative Gerard,
No.
Representative Grund,
No.
Madam Chair.
Yes. The motion of ought to pass with amendment on House Bill 348 passes with a vote of 9 to 8. The committee recommendation on House Bill 348 will be ought to pass with amendment, and that will go on the regular calendar. Representative Karazinski, would you like to author the majority report? Minority report? Okay. Representative Stavis will write the minority report. Okay, and with that, I will close the executive session on House Bill 348. Next, I will open the executive session on House Bill 453, an act prohibiting municipalities from banning use of grounds maintenance and snow and ice removal equipment with internal combustion engines. So the chair recognizes herself for a motion, and I move House Bill 453 in expedient to legislate. Is there a second?
Madam Chair, I'll second that.
Thank you, Representative Murphy. So, as you know, we had a full committee work session on this bill, and the prime sponsor did not attend to participate in that process. And despite the fact that the committee did work on this bill in the full committee work session, there's a lot of questions that the committee was not able to get answers to from the prime sponsor. So for that reason, in my opinion, the committee is unable to understand the bill, to actually work on the bill to come up with amended language. and nor do we really fully understand the reason for the bill. So, yeah, we can't make an informed decision. So, further comments? Representative Dolan.
Thank you, Madam Chair. I can still believe that when you have a situation where the prime sponsor does not make him or herself available to answer questions, that the bill almost automatically ought to be ITL. And the fact that that's the potential disposition of this bill, I think that's the right decision.
Thank you, Representative Dolan. Further comments? Representative Majori is recognized.
Thank you, Madam Chair, and just to echo Representative Dolan and to commend you on sticking to a policy, just what we do. So thank you for doing that.
Thank you, Representative Majori. I will correct your use of terms. It's precedent, not policy. Or practice. Okay, practice. So, thank you. Further comments? Okay, let's see. So, seeing none, the motion before us is an expedient to legislate on House Bill 453. If you are in favor of that motion, you will vote yes. If you are opposed to that motion, you will vote no. The clerk will call the roll.
Vice Chairman McDonald?
Yes.
Representative Guthrie?
Yes.
Representative Dolan?
Yes.
Representative Aylward?
Yes.
Clerk votes yes. Representative Franz?
Yes.
Representative Karasinski?
Yes.
Representative Murphy?
Yes.
Representative Walker?
Yes.
Representative Stavis?
Yes.
Representative Gilman?
Yes.
Representative Majori?
Yes.
Representative Colby?
Yes.
Representative Germana?
Yes.
Representative Gerard?
Yes.
Representative Grund?
Yes.
Me?
Madam Chair?
Yes. Yeah. Yeah, because Frog does that. So the motion carries with a vote of 17-0. Therefore, the committee recommendation on House Bill 453 is inexpedient to legislate, and that will go on the consent calendar. So I suppose I will write the committee report. Okay, and with that, I will close the executive session on House Bill 453. Next, I will open the executive session on House Bill 458FN, limiting local assistance to U.S. citizens or permanent legal residents. Do I have a motion? Representative McDonald is recognized for a motion.
Yes, Madam Chair, I'd like to recommend ITL.
Thank you, Representative McDonald. Is there a second? Representative Franz is recognized.
Thank you. Yes, I second that motion.
Okay, thank you. Representative McDonald, would you like to speak to your motion?
Basically, it's the same reasons that we just considered for HB 453. I'll leave it at that. Thank you.
Further comments? Okay, seeing none, the motion before us is inexpedient to legislate on House Bill 458FN. If you are in favor of that motion, you will vote yes. If you are opposed to the motion, you will vote no. The clerk will call the roll.
Vice Chair McDonald?
Yes, please.
Representative Guthrie?
Yes.
Representative Dolan,
Yes.
Representative Aylward,
Yes.
Clerk votes yes. Representative Franz,
Yes.
Representative Karasinski,
Yes.
Representative Murphy,
Yes.
Representative Walker,
Yes.
Representative Stavis,
Yes.
Representative Gilman,
Yes.
Representative Majori,
Yes.
Representative Colby,
Yes.
Representative Germana,
Yes.
Representative Gerard,
Yes.
Representative Grund,
Yes.
Madam Chair.
Yes. The motion passes with a vote of 17-0. The committee recommendation on House Bill 458 FN is inexpedient to legislate, and that will go on the consent calendar. And Representative McDonald, will you write the report for the consent calendar?
It would be my pleasure.
Okay, thank you. So with that, the chair will close the executive session on House Bill 458 FN. So moving onward here, I would like to say that, as you all know, we spent some considerable time and a full committee work session with regards to House Bill 488. And I commend everybody for getting through that and coming up with amended language to that bill. So as I said before, some members of this committee did in fact work on that during their lunch break. And given all the time that we spent and all the hard thought and work that went into this, myself, Vice Chairman McDonald, Ranking Member Stavis, and Deputy Ranking Member Maggiore, we decided that we would take further time to make sure that the input that we receive during the full committee work session is properly and meticulously recorded so that it can be submitted to OLS and we get an amendment that is a product of the fruits of our labor during the full committee work session. I do not feel that it's prudent to rush this just to finish the business today. So would Representative Stavis or Maggiore or Vice Chairman McDonald, would you like to further comment? Representative Stavis.
Sure. Thank you, Madam Chair, and thank you for considering that request to postpone this. I mean, this is a well-intentioned bill. It's a complicated bill. We devoted many hours of work to it this morning, and because it has so many moving parts, and because we all know that the drafting process in OLS, particularly now during the filing period, is very hectic and very busy, it's going to be a while before we get back a product. And even a longer while before we can proofread sufficiently that product to make sure that it's what we and the sponsor intend it to be. So I commend you on making the decision to put this off.
Okay, so at this time, what I'm going to do is I am going to recess this executive session until the call of the chair. And that will provide sufficient time to get an amendment in our hands so that we can then properly exec that bill. So I don't need to close the executive session. It is now recessed. So hold on for 1 second. Okay, so I have my concluding announcements. So for now, with that, that will conclude our publicly noticed business for today. So what I'm going to ask now before we leave in recess, I would ask that committee members please email me your committee reports, majority and minority reports, as soon as possible. But at the same time, please take time, care, and consideration to properly write those reports. Don't rush it. There is time, but if at all possible, I would like to be able to get those reports in before the deadline, which is next Wednesday. So that would give us a week. Does anybody have any difficulty with meeting that? So what I'm looking for is by Monday, if you can get those reports to me earlier, that would be great. I could review them. But does that sound reasonable to those who have volunteered to write reports? Okay, so yes. So lastly, I would ask that everybody be attentive to your email as well as to the House calendar for upcoming House sessions, that is veto day, as well as for the continuation of this executive session, which is in recess. So does anybody have any comments or questions? Okay, so seeing none, again, thank you for coming to this committee meeting today, and I guess we'll see you on veto day. Thank you.